Hey, Travis, this is Dave Fleener. Can you hear me okay?
David, I can hear you. Can you hear me fine?
Fine. I'm using a new computer. I think we're all in our basement somewhere. So.
I can hear you fine.
Okay.
Okay, good morning, ladies and gentlemen. We are convening here in the Franklin Circuit Court on February the 18th, 2021 for hearing on motion for temporary injunction in case number 21 CI 89, Governor Beshear versus Speaker Osborne and others. And the case has it's been fully briefed, and I think we're ready to proceed. We are on the record, and we're conducting this hearing through a Zoom call, which will be recorded for purposes of the record. So with that said, why don't I ask if we could begin with council making their appearances. I think I can see everybody or hear everybody, but let's just do a little test run, and I'm going to call on council for each party, and then you all can introduce your colleagues who are also with you or working on the call or who may be speaking today. So let's start with the plaintiff, and I will call on Ms. Cubbage to enter her appearance and to introduce anyone who will be working with her here today.
Good morning, Your Honor. Thank you. Just for the record, this is Amy Cubbage, General Counsel on behalf of Governor Beshear. With me also on behalf of Governor Beshear is Travis Mayo, Taylor Payne, and Laura Timpton. We also have on the line or on the Zoom call, Wesley Duke on behalf of Secretary Friedlander, the other plaintiff.
Okay, thank you, Ms. Cubbage. And then let's let me call on Mr. Maddox then to enter his appearance and introduce anyone from the Attorney General's office.
Morning, Your Honor. Victor Maddox for the Attorney General. With me on the call are Carmine Icarino, Chad Meredith, Aaron Soletto, and there may be others.
Okay. Okay, and it looks like that we have got Mr. Lycan for the Speaker of the House. Is that correct?
That's correct, Your Honor. Eric Likens for Speaker Osborne for the purpose of asserting legislative immunity.
All right, making a special appearance, and I see we've also got Mr. Fleener representing the President Stivers, correct?
Yes, David Fleener representing President Stivers. I also have Jeff Harmon from our office who is on the call with us. And like Mr. Likens, this is a special appearance. We're not waiving our immunity at this point.
Correct. Right. Okay. Very, very good. And welcome to Mr. Harmon. I'm glad to see him back before the court. And
thank you, Your Honor. It's a pleasure.
Let's see. Okay. Are there any other counsel that need to make an appearance? I think
Judge.
Mr. Woolsey, I see from LRC, right?
Yes, Your Honor, and also entering an appearance for the purposes of asserting immunity.
Yeah. Okay. So glad to have you with us, Mr. Woolsey. And I think that completes the counsel for everybody who's a party here today. So unless there's any preliminary matters that we need to discuss, I'm just going to go, we'll plow right into the plaintiff's motion for injunctive relief. So.
Your Honor, there is one preliminary matter I would like to bring up.
Okay.
Just to get clarity and to make sure that we're all on the same page. I know we are here on our motion for injunctive relief, but the Attorney General and his response also included a motion to dismiss for mostly for jurisdictional issues, mostly case or controversy type issues. We would ask that we be allowed to file a formal response to that in due course, and that is and that not be deemed ripe for argument today.
Okay. Okay.
Your Honor.
Mr. Maddox.
Thank you, Your Honor. We have filed a motion to dismiss, and we do raise jurisdictional questions. We think it's appropriate for Your Honor to consider the jurisdictional issue at the outset. We think it's inappropriate for Your Honor, for instance, to hear evidence and to proceed to the merits of request for injunctive relief until the court has determined that there is, in fact, a case in controversy and that the court has jurisdiction under Section 112 of the Constitution. I understand that the governor intends to call witnesses today. I asked if there would be witnesses. I asked who those witnesses might be. I wasn't told who those witnesses might be, but I do think that the court should consider its jurisdiction before it proceeds to that point. So I would join in Ms. Cubbage's request that the court brief that question before it proceeds any further. With respect to Your Honor's observation at the outset that the case has been fully briefed, I want to point out that at the conclusion of our memorandum and motion, we indicated that if the court did find that it had jurisdiction, we would seek to brief the merits and defend the constitutionality of the statutes in question. So we have not yet done that.
Sure. No, I understand on the merits. Obviously, we've got a different set of questions. And obviously, it does appear the Attorney General has, in the memorandum that has been filed, has raised the jurisdictional issue and styled that as a motion to dismiss as well as a response to the motion for injunctive relief. So we'll have a discussion of that before we recess here this morning. But it does appear to me that, again, as I indicated in my initial order, I think the court has enough briefing before it to make at least a preliminary determination that I think the court does have jurisdiction, although that's certainly subject to a more full review after you all have completed any additional briefing you want to submit on it. And I would say Ms. Cubbage's brief and the reply brief that they filed last night appears to address many of those issues. So again, we'll discuss before we recess this morning the procedural steps that we need to take to resolve those issues. But I do think the court feels confident in that there's enough evidence in the record and enough legal memoranda for the court to make at least a preliminary determination that jurisdiction is appropriate. So I'm going to go ahead and hear the motion for injunctive relief, and then we can talk about any supplemental briefing that needs to be done to get that motion to dismiss and the jurisdictional issues.
Yeah, I appreciate that, Your Honor. And I could just make one other comment. This is the second hearing we've had in this case, Your Honor. The first hearing was at 9 o'clock following the filing of a 55-page complaint and a 50-some page memorandum at 6:30 in the evening the night before. Last night, we received the governor's response, a 25-page memorandum at 8 p.m. Before this morning's 9 a.m. hearing. And I would just ask that if we have future hearings, that the governor and his counsel give the other parties to the case more opportunity to review and respond to those kinds of filings before we're expected to present argument and deal with those issues in front of Your Honor.
Okay. Well, and again, that's probably my fault in terms of the order that I entered regarding this hearing. I wanted to make sure everybody got an opportunity to brief it. Typically, the reply brief is the last briefing that's done on a motion. But again, I'm happy to hear any additional argument that the Attorney General wants to offer. We'll talk about that again before we recess here this morning. So with that understanding, let's go ahead and move our focus then to a discussion of the governor's motion for injunctive relief. And I'll recognize Ms. Cubbage to present the governor's argument.
Thank you, Your Honor. I just want to make sure that we handle this in the way that you would prefer. We obviously are prepared to argue our motion with respect to all three bills that are in front of you. We do have two fact witnesses that we are also prepared to offer, as Mr. Maddox alluded to. Your order had listed expert witness disclosures, and we are not presenting any experts, but we are prepared to offer Dr. Stephen Stack and Nicholas Hart as fact witnesses about the effect of these bills on both the State Department for Public Health and the Louisville Metro Department for Health and Wellness.
Okay. All right. Well, I will let you all proceed. And again, a motion for injunctive relief. I think parties have a right to present whatever testimony they want, subject to cross-examination. So Ms. Cubbage, I'll let you, if you want to present your an opening statement or an argument first, you can do that. Or if you want to call a witness, I'll leave that up to you.
Well, I would like to make one preliminary statement here. I know that Your Honor has seen the briefing, and we obviously have parties who are alleging there are jurisdictional issues, but with regards to the substance of our motion, there has only been one substantive response. And so far that has been President Stiver's response with respect to Senate Bill 1 and Senate Bill 2, understanding they haven't waived their immunity in presenting that. So I think it's important to point that out at the outset, that there has been no real attempt to challenge our substantive claims here, especially with respect to House Bill 1. So while we will still make our record here, we believe it is appropriate for, well, we obviously believe that we are entitled to preliminary injunctive relief on all three, but obviously in particular with House Bill 1, where no party has even attempted to challenge the evidence and arguments that we have put in the record. But
Your Honor, may I address that?
Okay, Mr. Lykin.
Thank you, Your Honor. First, we don't believe there's any party before the court who has reason or standing to address the substance. But I'd like to point out legislative immunity, while absolute, is not automatic. The case law regarding legislative immunity provides that all a legislator has to do is to show up and declare that he is asserting legislative immunity, and that's the end. And clearly I have done so on both appearances, and therefore relief is both as to legislative immunity and under the Declaratory Injunctive Judgment Act, excuse me, is inappropriate against the speaker.
Okay. Well, again, I understand the immunity arguments the speaker is asserting, and so you know, the court will ultimately address those. But we're here on a motion for injunctive relief this morning, and so I want to give everybody, including the speaker and the governor, the opportunity to make the record that they want to present to the court and for appellate review. So I'll just again defer to counsel as to how you all want to do that. So however you choose to proceed is going to be fine with me. So so with that understanding, again, I'll let Ms. Cubbage present her arguments or her witness, whatever she chooses to do.
I think it sounds like, Your Honor, then we are ready to call our first witness, Dr. Stephen Stack, who is here on the Zoom. Okay,
I see Dr. Stack. Looks like he's now unmuted and on video. So Dr. Stack, before you answer questions here, I need to administer the oath. So I'm asking you to raise your right hand. Do you swear or affirm the testimony you give the court will be the truth and nothing but the truth?
I do.
All right, then Ms. Cubbage, you may ask.
Dr. Stack, could you please state your full name for the record?
Stephen Joseph Stack,
And what is your current position?
Commissioner for Public Health for the Department for Public Health in the Commonwealth of Kentucky.
How long have you been in that position?
Just over 1 year. I began February 10, 2020.
What is your educational background?
I have a Bachelor in Arts focusing on classical studies and pre-medical studies from the College of the Holy Cross, a medical degree from the Ohio State University, emergency medicine training from the Ohio State University, board certification in emergency medicine through the American Board of Emergency Medicine, and a master's in business administration from the University of Tennessee, among other, more minor qualifications.
Could you briefly summarize your job duties as Public Health Commissioner?
I am the senior executive leader for the Department for Public Health, which has a wide array of charges for promoting the public health and safety for the people in the Commonwealth of Kentucky. Included in those responsibilities are the oversight of a division of epidemiology, which deals with communicable and transmissible diseases and other infectious and non-infectious threats. Also a prevention, the department or division rather, which deals with emergency response efforts. So it's a preparedness division, I apologize, that deals with emergency response efforts. There are also numerous activities related to maternal and child health, women's health, cancer screening and prevention, and numerous other medical and public health concerns. And that just begins to scratch the surface, I think, of the breadth of the department.
Well, we're obviously here today to talk about COVID-19, and I know you're not here as an expert on COVID-19, but can you give us, and we all, I think at this point, know what COVID-19 is, but can you give us a brief description of your understanding of what COVID-19 is?
Yes, COVID-19 is a viral infectious disease that was not known in the human species before late 2019. began in Wuhan, China, and in the span of less than 2 months spanned the globe and had already reached the United States of America. As we sit here today, COVID-19 has resulted in the death of more than 2.4 million humans across the planet, nearly 500,000 Americans, and more than 4,300 Kentuckians. It's spread primarily through respiratory contact, when people's secretions from their nose or their mouth transmit to other people's mucous membranes, most commonly their mouth, their nose, their eyes, or inhaled into their lungs. The infection in many people is relatively benign, but in a subset of people is lethal. It has a mortality rate in Kentucky currently 1.1%, which is approximately 11 times more fatal than influenza is in the state of Kentucky. Globally, the death rate is closer to 2%. It is much more dangerous for the people who get it than influenza or other common respiratory infections currently circulating in the human population.
Okay, what is the Department of Public Health's role in addressing the COVID-19 pandemic?
So the Department for Public Health has numerous responsibilities. One is the surveillance of the disease, gathering information, being aware of its impact on the people of Kentucky. Another role that is primary is taking steps and interventions to protect the people in Kentucky from unmitigated spread of the disease and preventable harm, including medical disability and death. So we have those roles. We also have mitigation and emergency response roles through our preparedness division. That includes gathering resources such as personal protective equipment, working in partnership with the federal government to distribute therapeutic medications and testing supplies and other resources to help the people across Kentucky respond to this emergency, be as well prepared as possible and mitigate its harms to people both personally, medically, and also in the more general course of their lives.
Knowing that as you mentioned, the COVID-19 pandemic hit Kentucky roughly last March, how has the Department for Public Health's response evolved from March 2020 to now?
This
Your Honor,
disease,
if I may, I'd like to note the speaker's continuing objection to this testimony. It seems Dr. Stack is testifying as an expert and not as a fact witness.
Okay, I'll note the speaker's objection, but I'm going to allow the question and the line of questioning. Although certainly, I'm cognizant of the fact we may have gray areas that between fact witnesses and expert testimony. Again, with the understanding we're here on a preliminary or a temporary injunction hearing and not to decide the merits of the case yet. So I'm going to give both parties some latitude and I'm going to, again, recognize the speaker's objection and I'll overrule it at this time, but we'll note for the record the continuing objection and obviously we'll need to address issues that are raised that any party feels have crossed the line into expert testimony. We'll give them plenty of opportunity to respond to that. Okay, you may continue, Ms. Cubbage.
Yes, the question was, Dr. Stack, how has the department's response to COVID-19 evolved across the pandemic in Kentucky, starting, say, in March 2020, taking it through now?
as I previously mentioned, the disease has been unrecognized or unknown in the human population until just a few months before our case, index case, March 6th, occurred in Kentucky. Very, very little was known about the disease. It was unclear how widely it spread, how lethal it might be, and what steps might be taken to mitigate its further spread and harm. We were aware at the time that hospitals had become overrun rapidly in China, and an entire Chinese province had been closed to entering or exiting traffic of people in order to impose a wide quarantine area around the province that was involved. And so across the globe and in the United States, very aggressive measures were taken to try to mitigate against and prevent the further spread of the disease, because the harm that it was causing in the first known area in China was so extreme that there was great fear and concern it could result in widespread death and harm. And so in nations and in states across the United States, emergencies were declared, and generally very broad steps were taken to try to reduce the interaction of people with each other, to reduce the risk of spread of disease. So travel restrictions were imposed, gathering restrictions were imposed, certain types of activity were restricted that were activities which were more likely to spread pathogen. And these activities were undertaken, as I mentioned, globally, nationally, and across the states. The United States of America declared a national state of emergency, and subsequently all 50 states in the United States of America declared states of emergency within their own boundaries in order to take these steps against what was perceived to be at that time a very serious threat.
Okay, and what were the steps that were taken in Kentucky by the Department for Public Health?
So in Kentucky, we began with the closure of numerous businesses. We closed down activities where people were likely to come into very close physical proximity to each other and at elevated risk for exchanging shared air or respiratory droplets. So obviously food and restaurant type activities, close gatherings in interior spaces where people come together for meetings and other gatherings were restricted. We did not require at the very beginning a mask mandate, as the evidence on that had not yet become solidified. We did urge people to maintain social distance from each other, to practice enhanced hand hygiene. And as we progressed through this, we methodically went through different types of social and business interactions that were at elevated risk for spreading the disease, and placed restrictions on those, as did virtually every other state in the country in some form or fashion.
How has that changed to now? Where are we now as far as the tools that the Department for Public Health is using to combat COVID-19?
Our knowledge of the disease has become much more detailed over the last year. We have also developed an evidentiary base that enables us to be much more precise in our interventions. So whereas in March of last year and April, there were many large-scale closures for a variety of activities, at this time, all activities essentially are open to some sort of business or engagement, though there are restrictions or enhanced measures in place. So whereas restaurants were not previously able to have in-person dining, now they can have in-person dining at a 50% capacity restriction to reduce the density of people and ensure proper social distancing. Whereas mask use was not required in March and April, mask use and mask mandates are now very common across the country, and even currently the national government has promoted masks as a requirement in any areas of transportation and others that they regulate and are able to do so. We have enabled more types of activity to occur. An example being in the spring of last year, K through 12 schools were closed to in-person instruction. K through 12 schools now are able to have in-person instruction and encouraged to have in-person instruction and hybrid instruction. They have learned a great deal more about the steps that they can take, and they've made adaptations, making different blends of in-person and virtual instruction possible to improve the hybrid experience. So we have tailored the interventions with more precision as time has gone on, as evidence has allowed us to do so, and as evidence has allowed us to permit progressively more activities with more confidence that the health systems won't be overrun, that the hospitals will still have capacity to care for people who have acute medical needs, and that people's understandable desire to return to their activities is obviously shared by all of us. And
No.
Dr. Stack, why is hospital capacity so important?
So I'll use an example. In Northern Kentucky and Lombardy, when they had their first patient show up with COVID, within the next 24 hours, they had almost another 30 or so patients show up in the first 24 hours. And then rapidly, the hospital was overrun. And a hospital that had a few hundred ICU beds had to more than double its full capacity for ICU beds in order to care for the people who showed up. So a number of cascading problems occur. When people show up abruptly with a large number of previously unknown, like a previously unknown infection like this, what we can do for those individuals is limited and becomes much more supportive care because there's not focused interventions we can take. So it's more complex, there's more difficulty, and the intensity required for each of them is relatively substantial. But when the hospitals fill up with a single type of patient, all the patients effectively have the same problem. That means that then you don't have capacity to care for all the other patients that have things like strokes and heart attacks and automobile accidents and appendicitis and other problems. So if the hospital capacities are exceeded, then other people who do not have the problem that caused the hospital to be overrun, in this case, COVID, other people without COVID start to suffer adverse consequence because now there's insufficient capacity to provide the medical and surgical care they need. And so what we end up seeing in instances like that is a disease like COVID, which may have a 1% mortality rate, may end up effectively resulting in a much higher mortality rate for the general population because individuals start dying from other conditions from which they would not normally die, but from which they do die because there's not sufficient medical and surgical capacity to provide for their needs. So it's very, very important to calibrate these interventions to do the very best we can to not have hospitals exceed their capacity and be overrun in a way that endangers not only the people who have COVID, but also endangers the general population who have a much larger variety of needs medically and surgically.
Is the Department for Public Health tracking any risks in the upcoming months related to COVID-19?
So the biggest risk that has become very prevalent in the news is the risk of mutations in the virus and variants. And there have been 3 that have been identified and talked about much in the popular press. One in the United Kingdom, one in South Africa, and one in South America. 2 of the 3 have been shown to spread more easily and be perhaps 50 to 70% more transmissible between people than the original COVID virus. The 3rd one in South Africa has shown some evidence of perhaps being more lethal at the individual level, so more dangerous to the individual people who get that. The danger with viruses is that they all mutate. Most mutations are inconsequential and have no performance benefit for the virus, if you will. But every now and then, when you have tens of thousands of mutations occurring because the disease is spreading so rapidly, some of those mutations, by luck, get better and give survival or performance benefit to the virus. And then you have more rapid spread or more lethal impact for the virus. And so these are big concerns now, also because it's not yet clear to what extent these mutations may or may not undermine the effectiveness of the vaccines that are being deployed. So while there is still a very large susceptible population, the more these mutated versions of virus spread, the more danger we're in of undermining the success of the vaccination and having a 4th and even larger wave of disease.
Shifting gears slightly, can you explain how the Department for Public Health coordinates with federal public health authorities?
There are numerous ways. So there are established communications between various agencies at the state and federal level. Some agencies are the Federal Emergency Management Agency, Health and Human Services at the federal level, Centers for Disease Control, Food and Drug Administration, the Assistant Secretary for Public Health at the national level. These entities, these offices and their staff have regular interactions with their state-based counterparts, sharing information, collaborating, identifying best practices, and trying to identify interventions that would be effective to promote public health and safety. In addition to that, individuals like myself engage in dialogue through other venues. So there's the Association of State and Territorial Health Officials, AASHTO, which is the equivalent of the National Governors Association for a state health official. And we dialogue on a regular basis, the state health officials across the country, to share current experience, knowledge and learnings, and try to the extent we can to coordinate activities and help each other in those venues because they convene a large proportion of state health officials. We not infrequently have representatives such as the United States Surgeon General, the Director for the Centers for Disease Control, the Director for the Food and Drug Administration, generals who are overseeing the vaccine distribution, and many others who are the very senior federal decision makers on these topics, who come and gather with us to hear our input and to share their input with us. So, and of course, there are innumerable emails and other communications that occur to give regular updates and bulletins back and forth. So and that doesn't even include the data sources where the CDC has routine established communications with state health departments and epidemiologists, sharing on a regular basis information both about the infection itself and also about the individuals affected by it, information identified through contact tracing and other avenues.
I noticed you just mentioned the Centers for Disease Control. Are you familiar with Centers for Disease Control guidance documents?
I am.
How does the State Department for Public Health use CDC guidance?
We use them as a reference tool. They're an expert body, well regarded across the world and in the nation. CDC promulgates literally in COVID-19. There are hundreds of documents. I don't know how many precisely at present, but multiple hundreds of documents, and each of which have been modified on an ongoing basis. Sometimes documents were changing week to week. Not necessarily always day to day, but at least week to week. And when you have hundreds of documents, many of which are changing on a weekly basis, it's a very substantial task, both for the CDC to keep those documents current with their current science and understanding, and also for all the state departments for public health to assimilate those and then to apply those more locally within our borders.
How do you assimilate those and apply those inside the borders?
So we have a team of hundreds of people at the Kentucky Department for Public Health who are skilled epidemiologists. We have people with medical degrees, PhDs, Masters of Public Health, and various other qualifications who have their own areas of expertise on different facets of this. Some are infectious disease tracking. Some have to do with deploying public health measures, logistics related to that. So we've done that with multiple pharmaceutical interventions, including their vaccine most recently. Those individuals are dedicated, trained professionals who read those documents, interpret those documents in the context of Kentucky-specific statute, regulation, and other considerations that are unique to the state of Kentucky, and then help make recommendations as to how to use those guidance documents and apply them within the Commonwealth of Kentucky.
Can you give a concrete example of how that might work, say, for restaurants?
So there are numerous different types of guidance the CDC promulgates, some that have to do specifically with food establishments or restaurants, others that would be with places of entertainment or venues, others which would have to do with just gatherings in general. The guidance across these is not necessarily uniform or consistent. The guidance often gives categorizations of various degrees of risk. They may say that something is high risk, something is medium risk, something is low risk. Seldom do they ever say something is no risk, because that would usually be the complete avoidance of a certain activity. It becomes necessary to review multiple different documents that are guidance for different descriptions of activity, but where certain activities clearly overlap those different guidance documents and those different types of activities. So a large gathering in a restaurant setting, in a ballroom for a catered event, effectively could be governed by multiple documents: the restaurant document, the venue document, and the mass gathering document. And it becomes necessary then to figure out how to distill that down into something more concrete and more actionable and interpretable by the general public and business owner operators for what's appropriate within their setting. So we engage in that process in an ongoing basis of reading those documents and addressing them. Education would be another example. The school guidance has evolved over the last 12 months until the most recent revision, which just occurred in the last week. I can't remember precisely, but the federal guidance document gave something along the lines of 9 or more different criteria, color-coded them by risk, and told the user to interpret those 9 or so different variables and reach a risk-based determination for what level of risk was present and then how to act upon that. That model required the person using those to have access to information that's not always publicly available, or that is requiring people with specialized training to properly interpret that guidance in the right context. So in Kentucky, that was translated into a color-coded guidance in partnership with the Kentucky Department for Education that made more simple and more discreet for the users of it a paradigm where they could use the incidence rate, which is the rate of disease present in a community adjusted by population, to determine what level of activity within schools was safely advisable. And so we just, and now actually I would observe the CDC's current guidance appears to have caught up with Kentucky guidance and now mirrors very similarly what we were already proposing in Kentucky. So I think there's a good example where the CDC, having to give very broad-based guidance that could be applied across numerous states, was refined more specifically for application in Kentucky in partnership with the educational community. And now the CDC's guidance with more evidence and knowledge has become further refined and actually now aligns very tightly with what we have done here in Kentucky.
You mentioned that part of the process is taking the CDC guidance and the risk discussion in those and distilling those into documents for the state's purposes that are concrete, actionable, discrete. Why would it be important to do that?
Well, this has been quite the experience as I've gone through this last year. We are clearly a rules-based species. Though we all bristle against having people tell us what to do, when people aren't told what to do with clarity, there's a whole another array of complaints that emerge. And so one of the frustrations along this 12 months has been when people have felt that they did not have sufficient precision and clarity in the guidance they were given so that they could know with concrete simplicity what they must or must not do. And so taking very diffuse guidance documents like the ones the CDC has clearly would have not worked in the state of Kentucky, and I would assert probably in any state in the United States of America. Communities are familiar with guidance in certain formats. What a restaurant owner gets looks different than what a principal at a school gets. It looks different than what someone may get who operates, an educational facility at the college level. And so translating general guidance documents into precise documents that can then be applied in the appropriate setting has been something that has been clearly necessary in order to facilitate compliance. It's also been clearly necessary and it many times desired by the audiences to whom they applied so that they could know with clarity and precision what it was they were supposed to do or not to do to keep the spread of disease as controlled as possible, to keep themselves, their employees, and the general public safe, and to make sure that they knew how to make use of the best knowledge and guidance available at the time. So it's clearly been very important to translate into more precise guidance documents and at times regulatory documents, materials for people to know with what they had to comply.
Now, we just spoke about how the State Department for Public Health coordinates with federal authorities. Can you now explain to me how the State Department of Health coordinates with local health departments?
We have 120 counties in the Commonwealth of Kentucky that are served by 61 health departments. Some are single county health departments. Some are district health departments, meaning that they serve multiple counties under the umbrella of one health department governance structure. And a few are independents where they sort of operate. It's the big city ones generally, Louisville, Lexington, Northern Kentucky, operate under somewhat different principles. I have regular communications with the local health department leaders and value them as my colleagues in this journey. Sometimes I have almost weekly discussions with them, with the commissioner and the health departments, to share information, to hear their concerns, and to collaborate. There are instances where we have collaborated specifically and reached some consensus guidance we've shared for the state. An example of that would be there was scientific ambiguity on the transmission of COVID-19 in classrooms when people were wearing masks or not masked. And the way the guidance was promulgated by the CDC would have placed further restrictions on schools and effectively said we had to quarantine entire classrooms under certain situations. And in conferring with each other, the local health department leaders and I as the health commissioner, we promulgated Kentucky specific guidance that specifically said if everyone was wearing a mask and seated 6 feet apart from each other, that no one would have to be quarantined in a certain setting, which was important for the school environment. Those kinds of collaborations on contact tracing, where we modified our approach to contact tracing when the disease burden grew so large that even with the massive escalation of staff we have hired over the last year, we couldn't keep up across the state. We had to modify our approach to how we did disease investigation and contact tracing. That was done in a consensus-based manner, with me as commissioner for the state convening the local health department leaders. And we reached a consensus and shared agreement. And I think that the state was well served in those ways. Those are generally exceptions to the rule, though, because in a normal operating for most of our activities, the State Department for Public Health promulgates the guidance or the rules, and the local health departments then become the enforcement arm for much of this. And in that, we just have open dialogue and communication to make sure we share with each other what we're setting out to achieve and how we might best do that. So I think it's been a very collaborative environment, and we've used multiple different approaches throughout this response to achieve what I hope has been a good outcome for Kentucky.
Does the State Department for Public Health have resources that local health departments don't have access to?
Oh, certainly, and many, and the local health departments rely on us a great deal for that. Laboratories report electronically directly through the Kentucky Health Information Exchange to the state. And the state gathers that information and then imports it into data systems that then the local health departments have access to. The state, as the primary vehicle for receiving and dispersing federal aid relief, has done things such as build up a customized IT system to support contact tracing, which is now a statewide system in which all 61 health departments now participate and share information. It's the first time we've had a statewide data sharing system for contact tracing in the state's history using that kind of technology. So that was a substantial accomplishment, but required a great deal of effort and work and resource that would not have been possible at the local level. It required the state to coordinate and bring about. We also have a large team of epidemiologists. We have a high complexity medical reference laboratory that at the very beginning of the COVID response was the only place in the entire Commonwealth capable of providing testing for COVID. And the health departments rely upon the state as a reference laboratory and for guidance related to testing. We also sequence the genome for the virus on a selected basis. And that's how we identified the first variant strains we were aware of in Kentucky related to COVID. Those are capacities that only reside at the state public health department and that do not reside and are not possible in the current reality in local health departments.
Based on your experience the past year, do you believe it is important to have a statewide response coordinated through the Department of Public Health?
Absolutely. I shared at the very beginning of my remarks that this disease leapt across the globe, and literally you can't get much further away than Wuhan, China, and New York City, New York. So that literally spanned the entire globe in a couple months. This is a disease that, if it can span the globe in 2 months, can certainly get from Pikeville to McCracken County in the span of a day or two. It can certainly get from Fulton County up to Boyd County in the span of a day or two. So if we did not have a statewide approach to this, the risk of unmitigated spread of disease is undeniably enormously greater. And we don't have to look any further than just to our southern border. In Tennessee, where they didn't impose statewide requirements in many ways, their death rate adjusted by population is double or more what we have here in Kentucky. And in fact, with the exception of West Virginia to our east, every border state around us has a higher adjusted death rate than the state of Kentucky does. And so I think part of our success has been the active coordination and collaboration between the State Department for Public Health, the local health departments, but also the hospitals with whom we've had regular dialogue, college and university presidents, school superintendents. I mean, we have actively been engaged in dialogue across large swaths of society in an attempt to have a uniform approach across Kentucky. And it's been difficult. And not at all times have we been able to achieve complete uniformity, but we have certainly achieved more uniformity than many states. And I think we've had the benefits of a lot fewer people dying and ending up in the hospital. I just observed we have not yet had a single hospital overrun in the state of Kentucky. There are probably a third of the states in the country who have had hospitals overrun at least. And so I think we have fared well because the people of Kentucky have collaborated very well during this response.
Are you familiar with what's normally referred to now as House Bill 1 that was recently passed by the General Assembly?
I am.
How would, if House Bill 1 were to go into effect, how would it change the Department for Public Health's response to COVID-19?
It would functionally render me powerless to protect the people in the state of Kentucky. And if I can expand on that.
Please.
It really is, it's the race to the bottom bill. It allows, it essentially substitutes any source you can find on Google for the authority of the executive branch in the Commonwealth of Kentucky to impose public health measures to protect the people of Kentucky. So functionally, the Google clause in that bill would allow any citizen to find any third-party source, whether it's a state or local government, whether it is a trade organization or professional organization, or any other, I can't remember the language from memory, any other affiliated organization or something along those lines that has a guideline of any sort, to find that guideline, to literally post it on their front door. So I imagine the legislature intended that people would nail to their front door a pile of papers, and then makes the state executive branch subservient to any publicly Googleable source. It makes the state government subservient to any third-party source, because the individual citizen or owner operator in House Bill 1 is empowered to select which guidance they choose and to select the least restrictive of any of those guidances. So functionally, this bill would render powerless the Commissioner for Public Health in the state of Kentucky and all the local health department leaders to take well-established, long-enduring public health measures to keep the people in Kentucky safe from infectious disease and threat. It really is staggering in its substitution for all these other entities in place of the executive branch of government as the determiner for what the statewide standard should be in an infectious disease pandemic.
Would the State Department of Health be able to review individual plans from businesses across the state for compliance?
Yeah, so there simply wouldn't be anywhere near the bandwidth, and nor pursuant to House Bill 1 would it matter, because we have no enforcement authority. It says very explicitly we are not allowed to enforce any standards as the State Department for Public Health or as the executive branch. So we could review them all we wanted to, but then the individual citizen could pick and choose whatever they wanted to. Functionally, it is the extreme case of caveat emptor. The individual member of the public would have to approach that pile of papers affixed to the front door of a place of business, read those papers, understand the public health implications of those papers, make their own informed decision if that were to be a safe place to enter or not, and then make that determination on an individual basis. Now, let's just take this away from infectious disease, because for some reason, people still don't fully appreciate how dangerous this disease is, which last year in 2020, it became the third overall leading cause of death in the entire United States of America. In January of 2021, COVID-19 was the leading cause of death, overtaking heart disease and cancer, with more than 3,000 people dying per day from COVID-19 in January. So this is not a minor detail. And that's why these points are really important. Let's take this to another context. If we were to apply this to building code, the same effect would be a plumber wouldn't have to follow any building codes. A plumber could go and look on Google and see someone who posted that you can use duct tape to affix gas lines. And the plumber now could affix gas lines one end to the other with some duct tape. And if then your house blew up because a plumber came in after having nailed on the front door of their place of business somewhere that the customer never went, that they found this online and this was their guidance document for how to join two pieces of pipe. If your house then blows up and burns to death your wife and 3 kids and your neighbor's house down at the same time, that would be perfectly permissible, because there's no reason for a building code, because in the executive branch of government would have no authority to impose a building code. Now, so apply this to any other setting, to food safety. So if you say, well, having cockroaches and rats in a restaurant kitchen, that's perfectly fine. That's natural. Well, we would apply the same thing, that if someone went online and found a description that it was perfectly reasonable to have insects and rodents in your kitchen in a restaurant, that's fine. As long as some third party said that that was okay, that would be sufficient. Additionally, this is public health through litigation. And it's a bizarre type of litigation. Effectively, since the citizen could pick the lowest standard, and since these standards are ambiguous, if they were to take CDC guidance, one of the examples that the House Bill 1 references, then some documents say you can't have public gatherings of a certain type. Others say you can have certain types of public gatherings. Some say you must do certain things, like have this distance or this mask use. And so they would go into this, find their own combination of specific guidance. And then where there was a disagreement, since the state is specifically precluded from enforcing any guidelines or any standards, this would all have to be litigated, where the bizarre outcome of the litigation would be one party arguing for the least restrictive protections against the people for the people of Commonwealth of Kentucky. So one of the proponents in the case would effectively be arguing to provide the least protection for all the people in Kentucky, who would then therefore be exposed to more harm and more risk. And so now the courts would become the final determiner of public health regulation in the state of Kentucky, not in the exceptional case where there's a disagreement between parties, but in the routine case where the guidance is ambiguous, and then ambiguity leads to great inconsistency. And then when the courts would have to, through litigation and case law, determine what will be the public health standard, case by case by case, business by business by business. It's very difficult to overstate the grievous danger that this bill represents for the public health safety and the incredible substitution of any random third party for the executive branch as the preeminent authority for setting regulations for the public health, safety, and well-being.
Are you familiar with what is referred to as Senate Bill 1, recently passed by the General Assembly?
I am.
based on your experience over the past year as public health commissioner, how would Senate Bill 1 affect your ability and the department's ability to manage the COVID-19 pandemic?
So doing this from memory is tough. And so I believe this is the one that would wipe away all the emergency orders after 30 days. Is that correct?
Yes, and Your Honor, if it's easier for everyone, I'm happy to share my screen and put it up on the screen. Is that permissible?
Yeah, that's fine if you want to do that.
So this, I think, if I'm remembering Senate Bill 1 properly, this is the bill that would essentially, from the 30 days from its enactment, are you blocked from sharing?
Yes, that's okay. That you're correct. That's the one we're talking about.
It would block every executive order that the governor has issued related to the current pandemic would be wiped away 30 days after the enactment of this legislation. And so functionally, every single protective measure we have taken to protect the people of Kentucky would disappear on one discrete day when this bill took force. It would egregiously endanger Kentuckians across the entire Commonwealth.
You mentioned earlier the risk of the mutated strains, the variants of COVID-19. If Senate Bill 1 were to take effect, would you be able to address those variants in a timely manner?
No, and in fact, now as I'm thinking more about this one, as I switch from House Bill 1 to Senate Bill 1, Senate Bill 1 would require a full-time legislature. So essentially, we've had numerous meetings a day, every day, working not infrequently from 6 in the morning until 9 or 10 at night on a regular basis. This would prohibit, if I remember right, the executive branch from promulgating any emergency regulation or order more than once in a 30-day period. And is this the one that blocks for 9 months afterwards, or is that Senate Bill 2?
That's Senate Bill 2.
Your Honor, the Speaker would like to note his objection,
Like-
not just to the opinion testimony, but this seems to be all legal opinion, not just medical expert opinion.
Mhm.
We object on that basis.
Okay. Okay. Well, again, I'm going to give all the parties some leeway here, and I do think it's important for the court to understand how the Department of Public Health would implement this legislation or the problems that the Department of Public Health has identified with regard to implementation. So the court recognizes obviously that to the extent they're legal issues, they're going to be decided in court and not by the commissioner, but the commissioner's understanding of the legislation and what problems it poses, I think is relevant for the court to consider. So I'll let Ms. Cubbage continue.
Thank you.
Well, Your Honor, thank you for that. I just on that point, I think it's really clear. I mean, I have quite enough to do as a commissioner for public health without, obviously litigation is the way civil people share their disagreements. And so I'm appreciative of the forum for us to have the discussions. I don't consider myself here rendering government or legal opinion as much as commissioner for public health. We have had to assimilate complex CDC documents on a daily basis that are changing, I already said, weekly, if not more often at times. We're having to make very complicated decisions using expert guidance that resides within the Department for Public Health, the national government, and also local health departments. In so doing that, we've had to move quickly. And because there are all sorts of consequences, we have had to move thoughtfully, trying to balance as best we possibly can. And I have said in other court testimony, I do not claim perfection. There are clearly things we wish could have been done differently or we had more options. But I do assert we've tried in good faith to keep the most number of people safe in Kentucky while trying to mitigate as much as possible the many other downstream consequences and undesirable harms. This legislation, this bill, has the direct effect of rendering powerless the Commissioner for Public Health to be able to promulgate using long-established laws. These are not laws that just suddenly were created this year. Laws that had been on the books and served us well it has the effect of rendering the Commissioner for Public Health and the people who report through me in our department, and then therefore by extension, the governor who relies upon us, powerless to promulgate rules and regulations that would provide for the Commonwealth of Kentucky some reasonable assurance that safeguards and protective measures have been put in place that do not subject the average member of the public to harms and dangers from which they could not protect themselves absent the intervention of state government to try to impose some kind of uniformity in a public health response. So I don't know where it begins and ends, what's public health and what's government, but I know that government has a role to play. The role of government in quarantine and isolation is long established and can be read in history books over the centuries. This is not a new concept. When people have infectious diseases and are a threat to others, it has been long established and shown in society that governments and and authorities step in and are recognized as having a role to place to take measures to protect the general public from preventable, unmitigated harm. And if we could crosswalk this to another example, Ebola, another viral infectious disease, Ebola, allowed to spread in unmitigated fashion, kills 9 out of 10 people that it infects. COVID-19 is not unlike the Spanish, we say the Spanish flu, but the 1918 influenza epidemic. The entire human population was susceptible to it at the same time, and it kills at least 1% of people, even when you have optimal medical care. So in this case, I guess I would respectively present my opinion that it's not just random commentary about what the roles of different branches of government is. In order for the people of Kentucky to have any confidence that they were being actively attended to and their safety considered, we would have to have the legislature in session continuously so that I could go over to the legislature, engage in committee hearings on a daily basis, and try to persuade legislative committees to take actions to keep the people of Kentucky safe. Absent that avenue, which is the avenue that this legislation proposes, the Commissioner for Public Health is powerless in this new paradigm from using the executive branch as a lever to promulgate steps that would keep the people of Kentucky safe, therefore requiring the active daily engagement of a full-time legislature. So someone else can interpret whether that's commentary on the law or not. It is the real world effect of what this would do in what I've done for the last year as the state health official for the Commonwealth of Kentucky.
No further questions for Dr. Stack.
Okay, Mr. Maddox, do you have any cross-examination for Dr. Stack?
I do, Your Honor. I appreciate it. I'd first like to just renew my position that the court doesn't have jurisdiction, and I'm not waiving that position by proceeding here today.
Right, court recognizes position on that. I'll let you go ahead and cross-examine, obviously, without waiving any jurisdictional arguments that you've.
Thank you. So, Dr. Stack, I want to take you back to last summer. I believe you testified in a proceeding in Boone County about 10 o'clock at night concerning some restrictions that were in question back then. And I believe you said then, or maybe it was previous to that, that the restrictions that have been imposed in Kentucky have been breathtaking in their scope. Is that correct?
It was read in the state Supreme Court, so it's not necessary to verify that. You can look at the record, sir.
I take it then that you agree that that is correct. Is that right, Doctor?
In a once-in-a-century pandemic, the interventions taken have been really substantial, yes.
Okay. So has the scope of the restrictions that you have imposed based on your public health recommendations changed in any dramatic way since then?
Can you please specify that more clearly?
Yeah, you said that there are still restrictions in place, correct, for almost every business in Kentucky. Is that right?
That's generally correct.
Okay, and public schools, by and large, are still closed, correct?
That's not correct.
Okay, is it true in Jefferson County? Are our state's largest county?
Define closed, sir.
Well, are the buildings open and are people, students, kindergarten through 12, attending school in the buildings maintained where teachers might otherwise gather to teach kids?
So the schools throughout the Commonwealth of Kentucky are permitted to return.
My question, Doctor, has to do with Jefferson County.
I'm not the commissioner for Jefferson County. I'm the commissioner for the state. So I can't comment on what they are specifically, their status is today, but they are permitted to, under current guidance, to be in in-person instruction as of January 4th, 2021.
So is it your understanding that KRS Chapter 158 has not been suspended, requiring in-person instruction?
The current guidance is that in-person instruction is permitted. And then there's as long as people follow the Healthy at School document and they follow the color-coded metric, but in-person instruction is permitted as of January 4th, 2021.
KRS Chapter 158 requires in-person instruction, doesn't it? As part of our efficient school system?
I'm not familiar.
Honor, I'm going to object. I know that obviously I was given a long leash, but we are talking about, Dr. Stack has already testified that he is not the head of the Jefferson County School Board. He's testified as to the scope of what the Department of Public Health has attempted to regulate. And we seem to be now arguing about decisions made by the Jefferson County School Board as opposed to Dr. Stack.
Yeah. Well, I'm going to give Mr. Maddox some leeway here too, although, I don't expect Dr. Stack to know I expect him to know the public health statutes and what his authority is under the public health statutes. I don't really expect him to necessarily be able to interpret the education statutes. And so I'm not sure how much more we're going to get. I will say I recognize Mr. Maddox has got a legitimate line of inquiry, I think, with regard to the governor's ability to suspend statutes and, what the interplay is between the governor's authority that's been delegated by the legislature to do that and the legislature's role in those decisions. But I'm not sure Dr. Stack can shed a lot of light on that, but I understand there's a legitimate question there. So I'll let Mr. Maddox continue.
Thank you, Your Honor. So Dr. Stack, I'd just like to establish, if you can, that it's your recommendation to the governor that led to, first of all, the order in November, for instance, that closed all public and private schools, correct?
Yes, at the time, I recommended that in-person instruction be suspended in November.
Did you have a specific study or basis in the literature for that recommendation?
The CDC guidance then enforced, and in fact, the CDC guidance currently in force, says that the single biggest determinant of disease spread within schools is community spread. And at that time, we were entering our now in hindsight, the largest, most sustained, most intense escalation of disease that we have seen throughout this entire pandemic, which we've just are now emerging from that surge. So at that time, when the disease spread was rapidly escalating, when we were beginning exponential growth in disease, the CDC guidance, which people unfortunately don't read carefully, which is part of the concern I've raised, says very specifically that community transmission is the single biggest determinant of transmission in the schools. So in that context, where we were having exponential growth and we already had a number of other measures in place, we had to take additional measures to slow disease transmission. And it does appear at this point that those additional measures, which didn't just encompass schools, encompassed other activities as well, have had their desired effect. And we managed to emerge from that surge without having hospitals become overrun or having cataclysmic collapse of the healthcare system. So, and the deaths increased, unfortunately, but they didn't increase to the magnitude they did in other states. So So yes, Mr. Maddox, I did recommend that in November timeframe, that we recommended the closure of in-person instruction.
And that was based on a specific scientific study. Is that right?
It was based on
Objection, Your Honor. He's misstating the
Well,
Dr. Stack's testimony.
Dr. Stack can straighten that out. I mean, I understood Dr. Stack to say it was his interpretation of the CDC guidance on schools.
Yeah, and Mr. Maddox, it's the CDC guidance. It's informed knowledge of numerous studies. It's dialogue with healthcare or public health professionals nationwide and locally. So it was not based on a single study. It was based on a much more comprehensive review of the evidentiary base.
You indicated a moment ago, Doctor, that SB1 would basically prevent you as the Commissioner of Public Health from using long-established laws to promulgate regulations to provide for the public health in the current climate. Is that basically what you said?
I think that's a reasonable summary, yes.
Okay. What laws did you have in mind?
Well, the laws that allow us to impose isolation and quarantine on an individual for an infectious disease threat, those are curtailed in these bills. The laws that allow us to promulgate emergency regulations and to do so on the similar or same topic multiple times over a period of time, if necessary, those are clearly curtailed. The ability for the governor in the state of declared emergency to issue executive orders in order to take steps that are necessary to minimize the spread of disease or protect people from the public health threat, those would all be curtailed because we wouldn't be able to do those for more than 30 days at a time without then either the concurrence, as I understand it, of the legislature or the attorney general in certain other settings.
So Doctor, I'm trying to understand here if there is a specific law or set of laws, and you've suggested that there is a long-standing body of existing statutory law that provides for your department to deal with public health issues. I think that's Chapter 214, isn't it?
I think that's correct.
Okay, and that gives the Department of Public Health the ability to provide for quarantine orders, doesn't it?
I believe it does, but I also believe that one of these Senate bills, if not two of them, specifically say that we're not allowed to impose quarantine and isolation on an individual.
Well, if SB1 or any of the other bills in question did that, that would be part of the legislature's exercise of its public policy making authority, wouldn't it?
Oh, I'm not disputing that the legislature can pass laws. It has passed laws. That's why we're here talking today. I was asked to opine about the implications and the consequences of those new laws, which I did.
Well, we're here because the governor has claimed that the laws in question, SB1, SB2, and HB1, are unconstitutional. And I'm trying to understand if you can agree with me that the Department of Public Health has ample authority under existing Kentucky statutory law, Chapter 214 in particular, to provide for the quarantine of people with infectious diseases.
Authority which is subverted by Senate Bill 1 and 2.
Are you sure about that?
The plain language reading of it appears to be the case. I don't offer an opinion on constitutionality. That the court will determine those things, and lawyers.
Okay.
But I will offer the opinion that the plain language reading of Senate Bill 1 and Senate Bill 2 specifically says that we may not impose isolation quarantine. In fact, it's one of the shortest sentences in the entire bill.
Let me take you back.
Go ahead.
Let me take you to another statement you made earlier. You indicated that SB1 would bring to a sudden halt all of the orders in place to deal with public health issues. Isn't it your understanding that the bill would easily allow for those orders to be re-implemented?
No. In fact, it's specifically precluded in at least one of those bills.
So if the 30-day time period that began to run on February 2nd expires on March 2nd with the legislature in session, is it your understanding that those orders could not be re-implemented in consultation with the General Assembly?
Well, so that's what I said is where we would require a full-time legislature, because whatever we were to go over there and attempt to persuade the legislature to adopt, and the legislature would then exercise its legislative authority to determine what it did or didn't adopt. That's not in dispute. I'm not contesting that the legislature has a role here. But then when the legislature leaves session at the end of March, then we would functionally be unable to render any more executive orders on these topics or any emergency regulations or regular regulations on these topics if that were allowed to stand in those laws without bringing the legislature back to concur with us.
Okay, I think we'll leave it to the lawyers in the case and to Judge Shepard to determine the extent to which, if any, SB 1 affects your department's ability to issue quarantine orders under Chapter 214. But let's move on for a moment. You indicated that we would have to have a full-time legislature. I take it, Dr. Stack, that when Governor Beshear issued his emergency order on March 6, 2020, in imposing a state of emergency, he did so with your recommendation, correct?
You know what? I don't know what the right answer for that one is, because March 6th is a long time ago, and I had just become the health commissioner. The governor, I have the privilege of advising the governor. The governor makes decisions. And in that case, the governor, in all these cases, the governor made a decision to declare a state of emergency, like the other 49 states in the country have.
Well, March 6th was a Friday. And were you the Commissioner of Public Health on March 6, 2020?
I was, but I don't recall that I had to be the one who advised him to declare a state of emergency. I think the governor made that decision on the basis of his consultations with his overall leadership team.
So is it your testimony that when Governor Beshear issued his state of emergency on March 6th, he had not consulted with you, the Commissioner of Public Health?
Your
No,
Honor, objection. He has answered this question.
Okay. Well, when were you appointed, Dr. Stack?
Right. So thank you. So I was appointed on February 10th, 2020.
Okay.
But when you're the question asking me, was I consulted in public health measures? Yes. But the governor is the one who declares a state of emergency, and I was one of his advisors.
Okay.
I had the opportunity.
Well, that's helpful. That's helpful, Doctor, and thank you, Your Honor.
Yeah.
Dr. Stack, I want to ask you this. So you've talked about the need for a full-time legislature because apparently these regulations are going to be ongoing. Do you expect that Governor Beshear will consult with you before he declares an end to the emergency?
The governor has consulted with me continuously throughout this emergency.
So what conditions will have to be in place for you to determine that the emergency should end?
That's so speculative, I can't offer you an opinion on that.
Well, do we have to get down to where there are no cases of COVID being reported on a daily basis?
No, we don't have to get to a case where there are no COVID cases, but we do have to get to a place where the United States of America and I mean, Counselor, here's the challenge with the way you're asking these questions. And this attempts to boil down into a false precision, an incredibly complex series of decisions in which the state of Kentucky is not itself always an independent actor as well. We operate in the context of a nation with 49 other states and a national government. At the moment, the nation and all 50 states remain in a concurrently declared state of emergency. The question about when we emerge from that emergency is a legitimate question. I respect that. And there is a legitimate need to know when. I don't know when that will occur. This is a once in a century pandemic, and none of us have gone through this before. It will ultimately be a shared judgment of hopefully a series of dedicated civil servants at the national and state levels in active dialogue, determining when the threat has abated sufficiently to not recklessly endanger the American people from this disease. So I'm not trying to be difficult in my response to you. It is simply, I decline to accept that it is as simple a binary decision as you are portraying it in the questions.
So if that's the case, I take it that we can't simply look at the statistics that appear on your department's website for daily cases, for recoveries, for cases by age group, et cetera, and draw any conclusions about how long you expect to need the emergency power you claim is in jeopardy by these statutes. Is that correct?
It's not correct, because you declared that you cannot draw any conclusions. Numerous conclusions can be drawn. But as far as when the determination would be made that the state of emergency can be safely lifted, it's far more complex than just looking at those individual variables you described.
Let me ask you if one conclusion that could be drawn from the statistics is that the governor's emergency orders have not been particularly effective. And I say that because on July 10, when the mask mandate went into effect, for instance, there were 426 cases based on your department's website. On December 10 of 2020, there were 4,324 cases. And that number had gone up almost monthly from the date that the mask mandate went into effect. As well, there were, shutdown orders of multiple businesses, religious organizations, ultimately of schools. On January 10, that number had dropped to 3,232, and today it's 1,017. It's not possible to look at that data and draw a conclusion that the trend supports the idea that the measures were effective, is it?
That is entirely incorrect.
Well, if they were effective, you would expect to see the trend line going in the opposite direction for 6 months, wouldn't you?
No.
Okay. Let me ask you this. You indicated.
Go ahead.
Let me ask you this. You indicated that there's a concern for hospital capacity. Today, 62% of the hospitals are at 62% occupancy, meaning 38% is available. ICU capacity is 34%, and ventilator capacity is 69%. There are 5,019 beds available in Kentucky and only 934 COVID patients hospitalized. So it's fair to say, isn't it, that as we sit here today, there is no crisis with the availability of hospital beds, ICU beds, or ventilators. That's a fair statement, isn't it?
No, and I'm going to link it to your previous statement. I'm just going to observe the disadvantage of the witness. I have no notes, no papers, nothing in front of me, and the council's able to read all sorts of facts and statistics I can't see or validate. So just if I could observe that. But so where you've made a number of misconnections in logic is, were the state of Kentucky the state of North Dakota during that same period of time, we'd have 4 times as many Kentuckians dead. So you have falsely equated the complete absence of disease with the profound mitigation of disease. We have limited the harm that Kentuckians have faced dramatically in the state of Kentucky.
I'm sorry.
Oh, go ahead.
I was just going to ask you, Doctor, isn't it also fair to say that there are states that have had far less significant lockdown orders, whose COVID case experiences, deaths per 100,000, deaths per million, are not significantly different from Kentucky's? That's true, isn't it?
No, I'm not sure that it is. There's probably examples of states that have taken different approaches, but you'd have to line up measure by measure and then align a number of other measures like population density, alongside of that to determine this.
So you don't know one way or the other if that's true, correct?
I'll dispute that it's not accurate the way you presented it.
Let me ask, before we leave the subject of the mask mandate that Mr. Maddox asked about, citing the, that there were 400 some cases on July 10 when the mandate was imposed, and then 4,000 some cases in December. And I guess I want to get Dr. Stack's understanding of whether that means that the mask mandate was not affected, or whether there would have been a whole lot more than 4,000 without the mask mandate, and what the experience of other states shows on that issue.
So, Your Honor, the problem here is exponential growth with disease. And I've said this in other settings repeatedly. So if you have doubling of a disease, if you go from 1 to 2 to 4 to 8 to 16, that's all doubling, but they're small numbers and we can relate to those, right? If you go from 1,000 to 2,000 to 4,000 to 8,000 to 16,000, those are numbers, right? And so the problem here is we have had 3 stages in this pandemic already. The beginning of exponential decline. We had it in March, we had it in the summer, and we had it again in the late November and December timeframe. When you have more disease and you start from a higher level, that effect has a much bigger implication. So what ends up happening is in the beginning in March, when we went from 1 to 2 to 4 to 8 to 16, and it was doubling in the beginning, we took all those measures we did and we stopped it in its tracks, and that's what we call flattening the curve. That's what got all the media attention. Fast forward to where we were in the summer, and we have hundreds of cases a day, and it starts to double. It goes up further from there, and then of course in the fall, even further. I think question, Your Honor, to finish the false equivalency here is to say that because disease increased, that the measure failed, and that is not correct. We interrupted an exponential climb of disease that where it was uninterrupted in states where they did not take measures, like no mask mandate in Tennessee or in the Dakotas where they really didn't take much measures at all, they had 2 to 4 times higher death rate as a result. Now, I talk about deaths, and I don't do that to be sensational. You can look at the hospitalizations too. If you look at other metrics, other measures of health systems being overwhelmed and collapsed, all of those measures performed terribly in these other states. And Kentucky had the particular harms of larger deaths and hospitals being overrun because of those interventions. So that I think it's been pretty clear that the public health interventions have helped.
Okay.
The work.
All right, Mr. Maddox, you may continue.
Thank you, Your Honor. I just have a few more questions. Dr. Stack, I want to go back to your discussion about the team of hundreds of people at the Department of Public Health who I take it are working on COVID. And you indicated that you and they work with the CDC. I believe you indicated you effectively interpret and translate the CDC guidance for the benefit of everyone else in Kentucky, and that CDC are the experts, but you effectively bring your expertise to bear and apply the guidance to sort of the Kentucky situation. Is that roughly what you said?
The only qualification I'd add is we are experts, they and we. It's not they are the experts and we interpret it.
Sure.
And they are both public health experts and we work in partnership.
Okay. So is there anything in the bills that you're aware of, SB1, SB2, HB1, that would prevent you and the hundreds of people from continuing to do just what you've described once HB1 went into effect? You could still work with CDC and apply the CDC guidance to the Kentucky situation and translate that and make it understandable for Kentuckians, for the legislature for that matter. Isn't that fair to say?
and no one would be bound to follow it.
Well, what happens if the emergency is ended? At some point, I assume it will be ended, won't it?
Yes, it will end.
Okay. So when that ends, is it your position that the legislature would be powerless to enact a bill just like HB1 that dealt with the lingering effects of COVID? I think COVID is going to be with us for the long term, isn't it?
I haven't disputed the legislature's authority to enact any legislation. I've just said what the implications of these bills would be.
So if a bill like HB1 were to go into effect, or if this bill goes into effect and the emergency at some point ends, everything the bill provides would still require people to understand CDC guidance, and your department would still have the hundreds of people who are working on it now who could help people understand that guidance, correct?
We can help to educate, but none of the guidance we promulgate would have the force of regulation or enforcement authority, because the bills that we're here discussing today specifically preclude our ability to promulgate or enforce functionally after a 30-day window, any regulations or orders related to these measures.
So is it your position then that the court should enter an order, effectively a permanent injunction, barring the legislature from passing any law that limited CHFS or the Department of Public Health from imposing mandatory restrictions on Kentucky businesses, Kentucky schools, Kentucky, the economy and society generally?
Objection, Your Honor. We're back to legal argument here with Dr. Stack.
Well, Your Honor,
I'll let Dr. Stack answer that to the best of his knowledge, understanding he's not a lawyer. So I kind of think maybe this has been asked and answered, but I'll let Dr. Stack answer it. Right.
So I'm commenting on the specific effect of three bills before us here today, HB1, SB1, and SB2. I have not postulated on what the legislature may or may not pass. I've only said what the implications and consequences are of these three bills. So I will leave it to the judge and the attorneys to determine whose constitutional role it is to do different things. I've said the effect of the current bills that we're discussing today would be, in order for me as health commissioner to enact in an ongoing basis in a once in a century emergency that's endured for a year at this point, that I would have to go to the legislature on an ongoing and frequent basis in order to get them hopefully to concur on recommendations. And if they didn't, then they could choose to do what they did. That's their prerogative as the legislature. But in order for me to promulgate orders and regulations of the sort we need, these bills would require me to have access to an in-session legislature on an ongoing regular basis. That's what I commented on earlier.
Well, that's helpful, Doctor. So just to conclude, if I understand your testimony, you don't know when the declared emergency might end. You believe that any imposition of legislative restraint on the exercise of emergency orders governing the shutdowns, the lockdowns, the size restrictions, capacity limitations, attendance at public events and the like would effectively render you powerless to protect the public health. Is that your testimony?
That's a false representation of what I've testified during this hearing.
Okay.
I did not say the legislature has no role. I commented on the specific impact of these particular bills. And so
okay.
I dispute the representation you've
okay.
my testimony.
Okay.
Your Honor, I have any other questions? Thank you.
Okay. Thank you, Mr. Maddox. Mr. Lycan, do you have any questions for Dr. Stack?
Just a few, Your Honor. Dr. Stack, good morning. My name is Eric Lycan. I'm counsel for Speaker Osborne. It's a pleasure to make your acquaintance. My first question, sir, is, are you aware whether or not the Uniforms Building Code is set forth in Kentucky statutes?
I'm not familiar with that specific statute. I'm sorry.
Are you aware whether or not Kentucky law allows, delegates authority to the appropriate cabinet to issue regulations regarding building codes?
I'm not familiar with the building code statutes or anything related to it in this setting, I don't think.
Sir, are you aware of whether or not there are statutes put in place regarding food safety?
There are statutes. I'm not specifically familiar with them by memory.
Okay. Are you aware whether or not Kentucky statutes delegate authority to the appropriate cabinet to make regulations regarding food safety?
There are statutes that delegate that authority. Again, I don't know them with specificity.
Are you aware how many days it would take the General Assembly to pass a bill or resolution extending a state of emergency?
I do not.
Okay. And for my final question, Doctor, have you shared all the opinions that you've given today with the General Assembly?
Well, that's an absolute, and whenever counselors ask absolutes, they're absolutely wrong. So, I mean, no, I have shared a lot of opinions. I've testified for numerous hours and dialogued with the legislature. But when you say, have I shared all? Well, that's unavoidably not correct.
Thank you, Doctor. Your Honor, I have no further questions.
Okay. Mr. Fleener, do you have any questions? I think you're still muted, Mr. Fleener.
Can you hear me now?
There you go. Yes,
Okay,
sir.
great. And with some trepidation from my experience when I worked for Dr. Fletcher and Dr. Holsinger, I rarely had any success in questioning doctors, but I will have just a couple here.
I'll take judicial notice of your
David Fleener. I'm general counsel to Senator Stivers, the Senate president. And I do have the advantage, I've got some of the documents in front of me, but I'd like to just ask you a couple questions specifically about your testimony and some of the bills that you've talked about. First with House Bill 1, and I've got that in front of me. And in talking about businesses operating, it says that they must meet or exceed all applicable guidance issued by Centers for Disease Control and Prevention or by the executive branch, whichever is least restrictive. You seem to indicate that businesses could just go out on Google and find something, but it seems like you've got two choices there, CDC or the executive branch. Did I characterize that correctly?
I think we need to project this bill, because if I can show it, I can walk people through, and then the others who are watching this proceeding can see there are other areas in that bill. And it does get difficult when I'm required to do this from memory, since I can't have notes, that HB1, SB1, SB2, I have not memorized the text of all those documents. However, it very specifically says in those that in one of those bills, that they can go to a trade association, they can go to some other affiliate organization, that they can get, and there's a variety of different options. So in that particular clause you read, it does say CDC or state government, but in a subsequent clause, it gives multiple additional options. It does say least restrictive. It additionally says that we may not enforce, that the state executive branch may not enforce any of these. So the fact that they found it on Google, nailed it on their door, and said they'll do it is rendered neutered by the fact that the state executive branch may not enforce even their own compliance with whatever guidance document they found. That's the effect, I believe, of House Bill 1. I think
But you would agree with me, Doctor, that it does say CDC guidance or the executive branch. And this is in section 1 of the act.
In one section of a multi-act piece of legislation, it says those words, but one, I think, will be required to read the entire act when it comes to interpreting how it's applied in the state.
I'm going to go over now to Senate Bill 1. Would you agree that at the end of the 30 days, the General Assembly has the ability to extend any of these orders? Is that correct?
I believe that legislation says the General Assembly can extend things for 30 if they want to beyond that.
This Senate Bill 1 was passed on January 9th of this year. Have you made any presentations to the General Assembly in those almost 2 months now, telling the General Assembly which of the executive orders need to be extended?
You understand, Counselor, that the General Assembly invites its own witnesses. So the General Assembly has not invited me, and therefore, if I have not appeared, it's the failure of the General Assembly to invite me to present to them.
So if we invite you, or we, meaning the General Assembly, invites you to tell us which orders need to be extending, you will in fact do that?
I have responded to every invitation the General Assembly has extended to me since I've been commissioner, sir. That's never been a dispute.
Now I'll go to Senate Bill 2, which deals with some revisions to Chapter 13A. You're familiar with the regulatory process, are you not?
My only qualification there is I'm familiar with it to the extent a commissioner would be. I rely on experts throughout government who are truly expert in the regulatory process and who help translate policy into regulation. So I rely on a team of professionals. So I wouldn't characterize myself as
aware, Doctor, of any instance where the General Assembly, through any of its committees, either its standing or statutory committees, has taken a position that they're finding a regulation to be deficient, that's a mandatory finding?
Explain that another way, please.
And I know because I've seen you appear in front of the committee for regulatory review. That committee can find a regulation deficient, but that in fact is an advisory finding, is it not?
You know, I'm
Let
trying.
me put it this way. If one of the committees finds a regulation deficient, the governor still has the ability to enact that regulation.
Yeah, so my hesitation here is not because I don't want to answer your question. I just don't want to give you the wrong answer. I show up where I'm asked. I comment on public health. I offer my input and advice. And then there are other experts who navigate the process of the government's bureaucracy. And I cannot tell you, and I cannot have confidence that I'm not being led down a path to say something that I don't intend to say, that you understand the process as well as I do, but probably better since you're all lawyers. I don't know in which cases what the legislature says is advisory versus what is binding. And so I have to defer to
It's
us.
okay, Dr. Stack, it's okay just to say you don't know, okay?
I don't know.
Okay, all right, Mr. Fleener.
And then ultimately, the judge is going to tell us that they're advisory anyway because of a case called LRC v. Brown. So I wasn't trying to trick you on that one, Doctor. We've talked a lot about CDC guidance. Are you aware that the director of the CDC has on multiple occasions said that the safest places for kids K through 12 is in school?
Yes, I am aware he said that.
Okay. I have no further questions, Your Honor.
Okay,
And thank you, Dr.
Thank you,
Stack.
Mr. Fleener. Okay, Mr. Wolseley, do you have any questions on behalf of LRC?
I do not, Your Honor. Thank you for the opportunity.
Okay, let's see. I think we've covered everybody then. And Ms. Cubbage, do you have any redirect?
Just a very, very few questions, Your Honor. Dr. Stack, does the concept of least restrictive have any meaning for you in the context of CDC guidance documents?
You know, I've read a lot of CDC documents, and I don't recall with clarity. I don't recall with clarity that term specifically, you know, drawing my attention. So, no.
For any of the guidance documents you've seen related to COVID-19, do any identify any conduct that is either absolutely allowed or absolutely disallowed?
No. Okay. Now, no, the CDC guidance specifically, okay, in this context, the CDC guidance, when I said I'm not familiar with it, I've read a lot of documents. I don't remember ever seeing that language. The CDC guidance has not used a framework that I'm aware of saying that the least restrictive approach is the preferable one. But then again, I think that concept is not a concept that they employ. They use a risk-based approach to things. So what they will say is there are different degrees of risk, and to the best of their scientific knowledge and understanding, here are different levels of risk. And so if you take these steps, we think you have this much risk. If you take these steps, you have that much risk. And so the CDC generally gives risk-based guidance trying to tell folks these actions are likely to provide this margin of safety. They generally reference it with scientific evidence. And it is often then left to the ultimate reader of the document to determine one, what risk they're facing. So they have to apply that, they have to use their knowledge of their circumstances to interpret the guidance. And then, of course, they have to make a decision what level of risk they're going to assume based on that paradigm in that particular guidance document. Does that answer the question?
Yeah. So you as a regulator, if you were trying to determine what is the least restricted conduct under a CDC guidance, would you be able to do that?
It'd be very difficult in a number of those documents because they're not even framed in that context. And so someone would have to functionally say, do I use the CDC document or some other document entirely? It'd be hard to determine if the CDC gives, because there's trade-offs, right? And so it would be hard. I mean, like the school-based guidance I said, I wish I remembered the exact number, but about 9 different criteria. So that was 9 different rows. And then there were like 5 different categorizations of risk. So it's a matrix decision-making. So it would be very difficult to determine, well, I'll accept this risk in this one and that risk in this one and this one and this one and that one and that one. So when you're talking about what is the least restrictive or the lowest risk, it would be difficult because a number of judgment calls have to be made even throughout a complex document like that to determine what balance or mixture of risk you're willing to accept.
Do you expect COVID-19 to the pandemic to resolve by March 31st?
Do I expect it to resolve by March 31st, 2021?
Yes.
I don't think there's any credible public health expert who would say it's likely to end by March 31st, 2021.
No further questions.
Okay. Do any of the defendants have additional cross for Dr. Stack?
No, Your Honor.
Nothing, Your Honor.
Okay. Dr. Stack, thank you very much for your testimony. We appreciate your insights and your testimony here today. And I'll let Ms. Cubbage call another witness if she has one, or we can take a short break and then come back and have arguments.
If I may just clarify, is Dr. Stack released to leave? We
Yes,
didn't want
he
him
is.
to leave without your permission.
No, Dr. Stack can be excused if I'm sure he's got other things that he needs to be doing today. So
Thank you, Your Honor, and thank you to the rest of you. I hope you all have a good day, okay? Thank you very much.
We do have one more witness, Mr. Nicholas Hart. If the court or if any counsel need a short break, we believe he'll be shorter than Dr. Stack. But if people would like a short break before we do Mr. Hart, or if we prefer to do that and then have a short break and do concluding arguments, it's obviously entirely up to Your Honor.
does anybody have a strong preference?
No, Your Honor.
Let's take a 10-minute break and then we'll come back and do Mr. Hart's testimony, and then we'll move directly into the arguments. Okay.
Thank you, Your Honor.
Your Honor.
participants, okay. Yeah, and then click mute. I may be back a minute or two early, so we can just stand at ease until we're sure that all council have had a chance to get back on the call. So.
Judge, you're probably going to get used to being able to put lawyers on mute from here on out. So
Yeah,
that's a handy function for a judge to have.
that's a very admirable part of the new technology here. So our family court judge has made the observation that on Zoom hearings that you know, that the lawyers are better behaved, but the clients are worse. So all right, I wonder, I think we've got everybody. I'm not sure if Mr. Woolsey and Mr. Lycan are with, looks like they are. And so I think we've got everybody back on the call. So we'll, let's resume now. And Ms. Cubbage, I think was about to call Mr. Hart. Is that correct?
Yes, and I'll turn it over to Travis Mayo for this witness.
All right, Mr. Mayo, you may ask, and let me administer the oath to Mr. Hart. If you would raise your right hand and unmute your device, do you solemnly swear that the testimony you give this court will be the truth and nothing but the truth?
I do.
Okay. All right.
Your Honor, may I just want to object that this is an evidentiary hearing that Your Honor ordered some weeks ago, and we've had no notice of this witness. I specifically asked yesterday for the witnesses to be identified.
Yeah.
We were not provided with that information. So I think it's, I just
Okay.
want to note my objection.
All right. It's an objection that the court, has some concerns about. So I'm going to overrule it, but I am going to give defense counsel some time if they need it to address any issue that may be brought up that's a surprise to them here today. So we can talk about that later. And Mr. Mayo, you may go ahead and ask.
Thank you, Your Honor. Mr. Hart, can you state your full name for the record, please?
Yes, it's Nicholas Ray Hart. Go by Nick.
Thank you, Nick. What is your current position?
Currently, I serve as the Assistant Director over the Division of Environmental Health, the Louisville Metro Department of Public Health and Wellness.
And how long have you served in that position?
Served in that position since November of 2020. Previously, I was an environmental manager for the Division of Environmental Health, having primary supervision over the the vector control, childhood lead poisoning, and hazmat response groups.
And what are your current responsibilities? Or if you could briefly summarize your duties and responsibilities as Assistant Director in the department.
So I work underneath the Director, Connie Mendel, who has primary supervision over environmental health, our public health lab, our public health preparedness group. Personally, I oversee our food safety programs, public facilities, plan review, as well as the other programs I previously mentioned.
And during this COVID-19 pandemic, what have your job duties, if you could briefly summarize what your job duties have been in that role?
I played a number of roles. I was onboarded in early March, where I served as a personal assistant to Dr. Moyer, along with another colleague of mine. When we filled out our incident command structure, I was assigned as the deputy branch director of our medical branch for our incident management team, serving underneath Dr. Lori Kaloya. And throughout the response, I've served also as our COVID compliance branch director, and currently I serve as the operations chief for Louisville Metro's, LMPHW, which stands for Louisville Metro Public Health and Wellness. So LMPHW's IMT operations section.
And what's the role and responsibilities of the department as a local health department of the largest county in Kentucky?
So when we're dealing with a public health emergency that deals with an infectious disease, we provide general direction to the entire city as our chief health strategist in responding to a public health emergency. We advise on the different types of branches that need to be stood up within the IMT structure, and we focus on those general public health practices of advising on communicable disease response, communications response, as well as the director of intervention actions. Additionally, our public health preparedness group guides the city of Louisville through this process, specifically when it's dealing with a public health emergency, as this team is a full-time team that plans, prepares, and organizes these types of response for Louisville and Jefferson County.
And what have those roles and responsibilities of the department been during this ongoing COVID-19 public health emergency?
So I always like to kind of frame this in the general public health kind of disease triangle, is that we have three primary functions. When we look at the interruption of disease, we have these categories of what we call the triangle, each side representing a different component. One side being the pathogen or the illness, the other side being the environment that creates that that setting that's conducive for the spread of disease, and then the third side being the host. So our role, to summarize quickly, is to try and remove one of these sides so that we collapse the triangle. And so we look at the types of intervention, we look at what we can learn about the disease to minimize or remove risk. We look at those communication strategies to be able to either treat or control the pathogen, to remove or create immunity in the host, or to control the environment to either remove that pathogen or remove the host, or impose safeguards to break down one of those sides to be able to stop infection. So the primary categories within LMPHW is that epidemiological response. So we track and record and we study the disease so that we can know how best to direct a response. We also perform a communications campaign to help build trust, to provide communications, coaching, and guidance. And then we actually have teams that perform those intervention actions to put in place safeguards, to provide public health response materials, such as PPE or other infrastructural assets and tools to break down that disease chain, or the infection chain.
Okay. And during this COVID-19 public health emergency, you've utilized those efforts, you've used those efforts for that triangle in Louisville Metro?
Correct. We help guide the standing up to that IMT process, where we mobilize the entire city, pulling assets not only from LMPHW, but from other city agencies, to create an overall structure to be able to respond on the county and citywide scale to the COVID-19 pandemic. And so we've directed the building of communication assets. We've directed the building of epidemiological assets. We've implemented systems for interventions. And currently right now inside LMPHW, we do have those branches that are represented by the communicable disease branch, our communications branch, as well as our compliance branch.
Okay. If you could, Nick, tell us about the relationship between your local department there and the State Department for Public Health.
Correct. So we're representative of one of those independent health departments that Dr. Stack spoke about earlier. We do have primary jurisdiction inside Louisville Metro and Jefferson County. We act as the chief health strategist inside that jurisdictional range. We do work very closely with the state health department, and in many aspects, we act as the agent of the state health department in many of the programs that we implement. For instance, inside Louisville Metro, we implement the state food safety program. We also have a few additional inclusions in our own food safety program, but in all aspects, we are the agent for that program, implementing that aspect of public health inside Louisville Metro in conjunction with, and as I think subordinate's the wrong name, but reporting to the state. We do that within a number of our programs, not only inside environmental health, but also inside communicable disease branch, our health services branch, and as well as our communications branch.
Okay, and what is that relationship between department there locally in Louisville Metro and the Department for Public Health at the state level. What has that been? Tell us about the relationship during the COVID-19 public health emergency.
So, in the simplest terms, we tried to coordinate as much as possible. Also, we take many of our directives, take much guidance from the state health department. They provide a number of services and tools and assets to our health department locally to be able to respond to COVID-19. We have very regular communications throughout all divisions of LMPHW, from our communicable disease branch, our compliance branch, our public health reporting. And essentially what we're trying to do is coordinate those functions so that we have a uniform response, not only within Jefferson County and Louisville, but also across the state. So we provide guidance back and forth with the state. We collaborate with them very closely, find that consistent messaging, can find those consistent modes of operations, and ensuring that the safeguards that we're taking inside Jefferson County and the interests that we identified are communicated to the state, and it could potentially be replicated in our neighboring jurisdictions, but also taking guidance and direction from the state to ensure that we are also matching those precautions that are being taken within or by our neighbors.
Okay, thank you, Nick. Are you familiar with a piece of legislation that is called House Bill 1 that the legislature here in Kentucky recently passed?
House Bill 1, yes, I am familiar with it.
And how would House Bill 1 affect, if it were to go into effect, the department's responsibilities in responding to the COVID-19 public health emergency?
It would change many of our operating practices that we've built over almost a year now. It would essentially tear down many of the structures that we've built. It would remove a lot of the standard operating procedures that we have designed, and we'd have to, start almost from scratch when looking about how to attack that intervention or that environmental component of the disease triangle. To think about how it would have affected the entire response is hard to imagine, especially when looking at House Bill 1, effectively removing one of our primary public health responses to COVID-19. When we look at it from the beginning, back in March, our primary intervention being testing and isolating and quarantining, which is a standard practice for many communicable diseases that we respond to, that we track, and that we report to the state, and then eventually gets reported to the CDC. That primary tool was the only public health intervention, was the primary medical intervention that we had essentially from March and until December, when those first vaccines were delivered to Kentucky. And so looking at House Bill 1, right now I am perplexed at how we would have been able to respond as a public health organization, and also perplexed at how we respond individually to each one of these cases. It essentially removes the biggest hammer that we have in our toolbox. Hammer's probably a bad term to use, but it would remove one of our primary interventions.
If House Bill 1 were to be the law, would it be difficult for the department to, what difficulty would it pose to the department in educating the public and entities about the COVID-19 disease itself and how to respond to it?
So again, I'm probably going to reiterate, I wish I had it up in front of me again. I've been trying to prepare as much as possible to remember specifically the effects of House Bill 1, but I think this is the least restrictive provision in there. You know, we had a fantastic tool that was provided to us by the state, being able to solicit feedback from the number of industries and entities within the state to be able to collect information and work with those leaders in those fields to develop guidance for each type of individual facility, individual organization, individual activity to create that uniform process across the board. And then that gave us the tools so that we could have larger conversations, so we could push out consistent communications to these industries as well as to the individual public about how we need to design our interactions with the public. With House Bill 1, moving that from just the simplest aspect to look at it on an industry-wide basis to looking at it on an individual facility basis, we would have to go in and inspect each facility with a door or each entity that's proposing an activity, ensuring that they had a plan, and then ensuring that that plan met the listed standards that are placed in House Bill 1, to then say, this facility is in compliance and that they can continue. And that's a challenge for us because we don't, as a regulatory entity, we have a process that comes to when we have these types of rules. We do education, that communications plan, right? And then once we're done with that, we do that education as much as possible on an individual basis, whether it be through industry groups or sometimes facility to facility. Once we're done with that education, we move into a coaching regimen. And then after those have been, established, then that's when we move into those compliance action, that enforcement action. It's very useful for us to do this on a large scale. That's what public health is. It's the regulatory process, the education process on a community level, as opposed to an individual person-to-person level. That person-to-person level is generally seen as the practice of medicine, where we practice community health. House Bill 1 would remove those tools and those assets so that we would have to go out and do education, coaching, and then compliance on individual basis, as opposed to having these assets that have been released by the state so that we can approach these on more of a community level. If we were thinking about a very busy business corridor within inside Louisville, take Dixie Highway or Hurstbourne or Taylorsville Road, the innumerable businesses that are in place and having to go into each one of those and conduct that individual education, coaching, and then compliance. I don't believe that we would have the staffing capacity to mount a effective response to COVID-19.
And based on your answer there, how would that affect the department's role in protecting the public health in Louisville Metro?
I think that we've had an incredibly successful response inside Kentucky. I think that it's amazing that we've been able to keep our case numbers so low compared to our neighboring states, especially as we have regional hubs for business as well as very large travel corridors. My first thought is we would not be able to have the effectiveness that we've been able to do in this response. I think it would have a huge impact on our capacity to respond. And I believe that would result in much larger case counts in Louisville, as well as within our neighboring counties, because this doesn't just, relate to, Louisville, Kentucky. We're dealing with a pandemic, meaning a global epidemic, right? And our response has to match the scale of the outbreak. And in Louisville, through our coordination with the state, we've been able to ensure that not only our jurisdictional response has been consistent, but our state response has been consistent. So we remove that consistency inside Louisville, but also with inside our neighboring counties have to respond again on this individual basis. And, you know, in Louisville, we have many people who work here with inside our jurisdiction who don't, you know, live or reside here. We also have people who live in Louisville who don't work in Louisville. And so, again, removing that consistent, uniform, continuous response, I can only assume would have resulted in increased case numbers that we would have seen in Jefferson County.
Okay. And are you familiar with the piece of legislation recently passed?
Your Honor, can I just interrupt for a moment? I think I would object to the last 2 minutes or so of Mr. Hart's testimony. I think it plainly calls for and was in fact expert opinion. And the last statement in particular, that somehow HB1 would have plainly called for or caused additional caseloads, is nothing more than supposition that witness is not qualified to offer.
Your Honor, you're on mute, sir.
Okay, I do think we're getting a little far afield here, and I am concerned we're kind of crossing the line into expert testimony too much here. So I'm going to sustain Mr. Maddox's objection to the extent that Mr. Hart has offered an opinion here, and you know, I'm happy to hear his testimony with regard to the practical impact as a public health officer of these three pieces of legislation. But I think we need to limit the testimony to the practical impact and see if we can't speed that up a little bit. So, Mr. Mayo, you may continue.
Your Honor, I would move to strike the opinion testimony offered by the witness.
Okay, well, I'll overrule the motion I'm going to sustain the objection, but I'm not going to strike the testimony, and you all can argue about it later. Okay.
Thank you, Your Honor.
Thank you, Your Honor. Are you familiar with the piece of legislation known as Senate Bill 1 that was recently passed by the state legislature?
Yes, I'm aware of it.
Based on your experience there as assistant director within the Louisville Metro Public Health and Wellness, how would, if it were to go into law, how would that affect the responsibilities and roles of the department in responding to the COVID-19 public health emergency?
So, House Bill 1.
Senate Bill 1, I'm sorry.
Excuse me, Senate Bill 1. I apologize. So, Senate Bill 1 does a number of action that I'm trying to keep straight in my mind. First, the inability to impose limitations on in-person gatherings. I will again repeat some of my previous statements in saying that when this pandemic began, our primary public health response was limited to testing and then identifying where disease existed, and then ensuring where we did identify that disease, whether it be in an environment or with a host, to isolate those cases to prevent further infection. And so going again back to the disease triangle, without the ability to limit in-person gathering, we are unable to restrict and regulate that environmental side of the disease triangle, which was our primary response until we were able to get vaccines. So the in-person gatherings affects that environmental side of the disease triangle. It would also limit our ability to impose isolation and quarantine. Isolation and quarantine on an individual basis goes to affect that side of the triangle considering the host. Quarantine and isolating is an accepted public health practice, one that has been enumerated by the legislative body of Kentucky as a needed and required tool to respond to a communicable disease outbreak. And so when we, as proposed by Senate bill, that we could not impose an executive order or a practice to require isolation and quarantine longer than 30 days, that would remove almost 10 months of our effectiveness in combating COVID-19, as that was our only public health response when we did identify where the disease was. So Senate Bill 1 would remove effectively two of our efforts to break down that disease triangle.
So what would be the practical impact of measures, public health measures issued by the state? What would be the practical impact on the local health department there in Louisville Metro if such measures could exist for only 30 days?
So I should state right now that yesterday I ended my 14th day of quarantine. My family also are finishing their 10th day of isolation. While I think that my family, due to my experience with them and their acceptance of my knowledge of response for COVID-19, would have isolated and quarantined regardless, without the ability to impose a quarantine, isolation, or limit groups for more than 30 days, would have again removed that primary tool, and we would be left to falling back on substandard practices of public health. That education and that communications piece, while I believe it is a very important intervention activity, we would be relying on voluntary compliance with recommendations that we could ask for but not require from individuals. And we've seen already a great deal of hesitancy throughout the state to follow those recommendations, and as well as intentional violation of those orders, even if they were in place at the time.
What would be the practical impact on the department's roles and responsibilities during this COVID-19 public health emergency if certain, for instance, in Jefferson County, incorporated cities within the county were permitted to not have any measures in place if they chose, while others continued or did have certain measures in place? What would be the practical impact on the department's roles and responsibilities if that were to happen?
So I appreciate that. It reminded me of another portion of Senate Bill 1, that being that local executives or legislative bodies can request to end those executive orders, whether they be from the governor and potentially even locally just within inside Louisville Metro's jurisdiction. So we have 83, I believe, I may be off by one or two there, independent cities within inside Louisville Metro. Senate Bill 1 would give those independent cities within inside Jefferson County the ability to pick and choose which executive orders they would like to follow. And again, as I spoke before, when we're looking at an epidemic, or in this case, a pandemic, and we're trying to develop a strategy of response, that response has to meet the scope of the outbreak or of the emergency, and being able to allow 83 independent cities to determine whether or not they were going to follow or not follow those recommendations made by the governor or our executives would put an overwhelming burden on LMPHW's response to COVID-19, specifically having to ensure that whatever municipalities that we were going into to perform our functions to break the chain of infection was catered to that specific organization or that specific municipality, ensuring that we are educating all of our environmentalists or other personnel who are going out to respond about the potential 83 different variations of those rules. We do not have the capacity to respond individually to that number of different municipalities and to construct a uniform, consistent, and continuous response.
Okay, thank you. And are you familiar with the piece of legislation known as Senate Bill 2 that the legislature recently passed?
Yes, I believe I am. Excuse me. Yes, I am.
Thank you. What would be the practical impact on the roles and responsibilities of the Louisville Metro Department of Public Health and Wellness if regulations issued by the State Department for Public Health or Cabinet for Health and Family Services and to address infectious or contagious diseases could only last for 30 days?
Again, we get back into, attacking that consistent, continuous, and uniform response. Takes a lot of legwork to issue an emergency Kentucky administrative regulation, as well as a Kentucky administrative regulation that's not in an emergency. In looking at this one specifically, digging in deep, I think reviewing it and its effects on our ability to implement quarantine and isolation and restrict in-person gatherings, again, removes the primary tool throughout this response. And looking into it further, I believe the effects on KRS 214, I think it's 0.020, in that KRS, the legislature recognized the need and the tool for isolation and quarantining and enumerated that practice in that piece of legislation. And if I'm correct, I believe House Bill 2 goes into that, Senate Bill 2 goes into that piece of legislation and removes the cabinet's specified and articulated duty, and then
Your Honor, if I could just interrupt, I object again. I believe the witness is offering, first of all, expert testimony, and second of all, testimony outside his field of expertise. To the extent that he offers his own opinion about what the bill might do or might have done, I think that's, something that should have been disclosed earlier and hasn't been. So I object.
Yeah. Okay. Well, let me do this. I'm going to sustain Mr. Maddox's objection to the extent that Mr. Hart's offering an opinion here. Let me just ask Mr. Hart, I guess the question with regard to Senate Bill 2, which imposes some limitations on the state's ability to enact emergency regulations, which are a tool, as I understand it, in the public health response to to the COVID crisis. Can you explain to the court what impact Senate Bill 2 and its restrictions on emergency regulations would have on your ability as a local public health officer to respond to the COVID crisis?
Correct. And I apologize. I was just trying to re-articulate what was written in the bill, as opposed to saying that I believed is saying, I'm sorry, I recall.
Just give me your understanding of how it would work on a practical level, okay? And what problems it would pose, if any.
In many aspects, we obtain our authority to impose isolation and quarantine and restrict limiting from the authorization of the state and through those KRS as an independent local health department. It's my understanding that that would be removed by what is proposed by Senate Bill 2.
Okay, so to the extent that the bill would restrict or limit the emergency regulation authority of the state, that would trickle down to also create an obstacle for the local health departments in enforcing those requirements. Is that fair to say? That's what your testimony is?
Yes, I believe that's what the bill states.
Okay.
Thank you, Your Honor. I have no further questions.
Okay, Mr. Maddox, you may ask.
Thank you. Mr. Hart, I'm Victor Maddox. I represent the Attorney General. We've never met before, correct?
I don't believe so. Not that I can recall.
Right. When did you learn that you would be testifying here today?
Last week, a request, I believe, was sent out.
Okay. And you've met with counsel for the governor on multiple occasions?
Yes, twice as a proposed witness.
Okay. Okay. Let me ask you about the testimony you just gave and which Judge Shepard asked you about as well. What part of SB 1 is it that you believe has to do with the authority in KRS 214-020, which I believe you mentioned, giving the Cabinet for Health and Family Services the ability to quarantine?
I'm sorry, you said in Senate Bill 2?
I'm talking about SB 1 right now. I believe you indicated in your testimony that you understood SB 1 would somehow take away the authority of the Louisville Metro Health Department to impose quarantine orders on people who are sick. Is that your testimony?
I'm sorry, I must have misstated. I don't think House Bill 1 provides that authority.
Okay. So is it your understanding that Senate Bill 1 or Senate Bill 2 somehow takes away the authority to do that?
I believe in Senate Bill 2, if I could look at the proposal, I could answer you more specifically, but if I recall correctly, reading Senate Bill 2, it removes the duty of the cabinet to operate a strict isolation and quarantine program.
Okay. Now, you understand that KRS 214-020 is not an emergency provision, right? That's been in place for quite a while, correct?
I'm sorry, say that one more time.
Yeah. KRS 214-020, which provides for the authority to establish and strictly maintain quarantine and isolation at such places as the Cabinet for Health and Family Services deems appropriate or proper. That's been in place for a long time, right?
Correct.
Okay.
Well, I have to look at the legislation to see how long.
Right. Well, it says it was effective on my copy in June of 2005. And, predecessor versions were in place before that. So if that's the case, you agree that the ability of the cabinet to write regulations concerning the quarantine of people with infectious diseases has long predated anything having to do with COVID, right?
Correct.
Okay. And I'm just trying to understand, is it your understanding that somehow the legislature has now determined to take that power away? In other words, that it has modified 214-020 to take away that power?
I believe I could answer better if we could review the proposal or the bill together, but I believe in there it strikes out the cabinet's ability to promulgate rules and regulations and changes that language to having to issue KRA. And then it also strikes out the duty to maintain a strict isolation and quarantine program.
Okay. Now, if it did do that, and if it applied to KRS Chapter 214, and in the ability of the cabinet to issue regulations and provide for the prevention of infectious diseases and contagious diseases and provide for quarantine. I mean, you would agree that that's part of the legislature's business, right? Writing statutes.
I'm going to object, Your Honor. The witness has testified as to the practical impact of these particular bills and not as to the legislature's role.
I've given both sides a lot of leeway. I'll let Mr. Maddox ask the question, and Mr. Hart can answer if he knows, and if he doesn't know, he can just say that's not within his pay grade.
So, Mr. Hart, my question is, let me rephrase it. Your testimony earlier indicated that you've got concerns, and I take it your department has expressed concerns concerning the wisdom of HB1, SB1, and SB2. Is that fair to say?
I would say that it could negatively affect our response and our department's ability to respond to COVID-19.
Now, insofar as anything in SB1, SB2, and HB1 has to do with the non-emergency provisions under which your department operates, in other words, just your ongoing authority to provide for public health, is it your position that the legislature does not have the power to modify that statute?
I'm not going to be able to respond to that. I don't know.
Okay. Let me ask you about the testimony you gave earlier about some of what you do on a regular basis and have done since COVID arrived. And I want to make sure I understand what you've said. You indicated that if these bills go into effect, somehow you would have to go down Taylorsville Road on a business by business basis and provide individual education on the provisions of the department's recommendations or something to that effect. Is that correct?
Yes, I did testify to something similar to that earlier.
Yeah, I'm trying to understand, what is it about the legislation in question that would require you to suddenly begin going door to door, as it were, to educate business owners about the health issues? I don't understand that. What is it that makes that necessary in the legislation?
It is the basics of operating a compliance and regulatory program. Again, not only do you educate, not only do you coach, but you also ensure compliance. And so in this situation, it would shift our ability to be able to communicate on a mass scale, to have a uniform response into an individual response. If each installation were able to come up with its own safety plan.
Well, doesn't the health department already inspect restaurants and give them a grade, for instance?
Yes, we do.
Okay. And a restaurant could be inspected at any particular time. You don't give them a notice that you're coming, do you?
No, we don't.
Okay. So what would prevent the department from following that approach in an environment after which HB1 had become law, and you arrived at a business and you inspected the business to see whether it in fact had a CDC compliant plan and that plan was in place? You could do that, couldn't you?
So we have hundreds of restaurants in Louisville, and maintaining compliance with COVID-19 would shift our ability, or excuse me, shift that focus, and it has shifted that focus to not only just hundreds of restaurants, but also thousands of other businesses, organizations, facilities, institutions. And because they do not have this simple one directive or set of guidelines that has been prescribed, then that would turn that into an individual analysis on a organization by organization, facility by facility basis, which we do not have the capacity to perform.
Okay. I think in related to that testimony, you indicated that HB1 removes one of the primary intervention methods that your department uses. And I take it that was the quarantine element. Is that correct?
I think it's one of the primary interventions that everyone uses for COVID-19.
Right.
So yes, that is the identification, limiting of groups, quarantining and isolating.
But as we sit here today, I mean, the health department only quarantines people who are sick, isn't that right?
No, nobody who's sick gets quarantined. So you're thinking of isolation. So individuals who are sick are asked in order to isolate. Individuals who had close contact with a case are required to quarantine.
Okay, so that's what the contact tracing program is all about, right?
Correct.
Okay. All right. Let me finally ask you, you indicated that there was some reluctance or hesitancy already evident in dealing with your efforts. I think that's generally what you said. If I'm misstating that, please let me know.
You may be misstating it. I'm not sure.
Okay, well, I think you said you would be required to rely on voluntary compliance only, correct?
I'm sorry. I was speaking about, yes, you are correct. Without the ability to order isolation, I was speaking about my family, saying that I think that they would have voluntarily isolated and quarantined.
Okay. So my question is, what data does your department have? And if this litigation goes forward, what data could we get from you indicating the extent to which there has been compliance or lack of compliance in Jefferson County with the directives of the health department or the governor's emergency orders? Do you have that sort of data?
I am not personally knowledgeable about that data.
Who would we talk to find that data in your department?
Our communicable disease team.
And who heads that up?
Your Honor, I'm going to step in and object to the witness.
Well, I'll let him answer that question.
let's see, Dr. Moyer is the director, and
Okay.
Dr. Sarah Beth Hartledge is the medical director over that division.
Okay,
If they are able to collect that compliance data.
okay. Thank you, Mr. Hart. No other questions this time, Your Honor.
Okay. Mr. Lykin, do you have any questions for Mr. Hart?
I have no questions, Your Honor.
All right, Mr. Fleener
No questions, Your Honor.
and Mr. Wolseley.
No question, Your Honor.
Okay. Mr. Mayo, did you have any additional direct examination or redirect?
Your Honor, just real briefly, the question that Mr. Maddox asked regarding restaurant inspections, are those in restaurant regulations, based on your experience as assistant director at the department, are those based on regulations that are uniformly applied to the specific businesses?
Yes. Across the state, we implement the state food code, which is based on the FDA's model food code.
And is that food code applied in non-emergencies?
Yes, it is.
Okay, that's all I have, Your Honor. Redirect.
Okay. All right. Mr. Hart, we appreciate your testimony and we'll let you be excused unless is there any additional recross?
No, Your Honor.
Okay. All right. So Mr. Hart, thank you for your testimony and we'll let you be excused. Okay. And Ms. Cubbage, I understand that that's your last witness. Is that correct?
That is correct, Your Honor.
Okay. All right. So, are we ready to go ahead and present legal arguments, or do you all want to take a break, or what's your suggestion?
We're prepared to finish up if Your Honor would like, but obviously, again, if counsel or anyone prefers to take a short break, we're absolutely happy to do that as well.
Your Honor, I'm ready to proceed.
Okay. All right. Then, Ms. Cubbage, I'll let you go ahead and present the argument for the plaintiff.
Okay, and just to give you a little roadmap of what we plan to argue, I will argue first about the equities and the harm with regard to injunctive relief, and then on the substantial legal question with regard to House Bill 1. Mr. Mayo will then pick up and argue regarding Senate Bill 1 and Senate Bill 2. And to the extent we need to have argument today regarding the jurisdictional issues, Mr. Payne will argue. So jumping in, I don't want to insult you by simply reading our brief or rehashing what was said at our last hearing. Obviously, there is a record here and we have the benefit of the prior hearing. I do just want to reiterate, as you noted in your first order granting the TRO with regard to House Bill 1, that we believe we have clearly presented that there is irreparable harm both to the governor and CHFS in discharging their duties both by statute and more particularly under the Constitution, and that there is a clear balance of the equities toward injunctive relief here. Looking no further than the Supreme Court's order this past summer in Beshear versus Acre about the need for a clear and consistent statewide public health policy. All three of these bills undermine that and similar but somehow distinct ways, which we'll go to in the legal question. I won't belabor those issues, but we believe that we have argued that in the briefs. Now, with regard to the substantial legal question with regard to House Bill 1, which obviously you have already enjoined. This one, perhaps most directly and plainly, currently shows the harm that we have regarding this bill and the need for a consistent statewide public health policy. As Dr. Stack and Mr. Hart both indicated, the way House Bill 1 works is every business can develop its own plan that has to purportedly at least comply with CDC's least restrictive, or the state, or somehow an executive branch, it's not clear what executive branch, the least restrictive type of restrictions that are available. And then you can obtain that plan from literally anywhere under the next part of the bill. And that's what Dr. Stack was referring to as the Google. So it's a two-pronged part here. You can get your plan from anywhere and you can tack it up so long as it meets the least restrictive elements of the CDC guidance. The problem with that, as Dr. Stack and as I think you recognized in your original order, is CDC guidance, that's a non sequitur with respect to CDC guidance. CDC guidance is written in terms of risk. There are activities that are deemed lower risk and higher risk, but there's no restriction in there. So to be consistent with the least restrictive activities in the CDC guidance means you can do anything, because it simply tells you the different types of risk. So what you're going to have is exactly what you recognized, Your Honor, in your order. You're going to have a patchwork of different types of plans, choose your own adventure, for lack of a better word, across every business and every jurisdiction in the Commonwealth. And as Dr. Stack and Mr. Hart have indicated, both the state health department as well as the local health department would have an inability to police that, even to the extent they're allowed to under the bill. And it would utterly undermine any consistent public health response we have right now. Even though numbers are dropping, as Dr. Stack indicated, we are in a time of great uncertainty, because even though we have vaccines rolling out, people are very happy about that. I know I personally am. I hope my parents get there soon. But we also have the risk coming of possible variants that have already, one of which has already been found in Kentucky.
Yeah.
If,
Let
I'm
me
sorry.
ask you, Ms. Cubbage, a little bit about the, I guess what your all's allegations are with regard to the immediate and irreparable injury here. I understand the arguments. I think that the bills are bad policy, which to some degree the legislature's got the ability to enact bills that may not be great policy, but the question is, how does that impair the governor's exercise of his constitutional duties? And I guess that's what I want to get a better grip on. And to some extent, it appears that this is a legislative scheme where the legislature has certainly in House Bill 1 is delegated the ability to make the rules that apply, not just to the governor, but to every business and nonprofit and entity in Kentucky to essentially adopt their own rules. And then the legislature has, in Senate Bill 1 and 2, has basically decreed if the governor exercises his authority in a way that doesn't, the legislature doesn't agree with, that then they can withdraw that delegation of power to the governor. So again, I guess I want to get a better understanding of what the governor's argument is as to how these acts impair his executive authority under the Constitution, and what his argument is on that discrete point.
Okay, it's actually a fairly simple argument. The Kentucky Constitution sets up obviously our separation of powers, and know that you've been here enough times to know that our separation of powers sections are fairly unique. And we have a very distinct legislative, we have a distinct executive, and obviously a distinct judicial, and no branch may exercise the authority of the other. With all of these bills, but with specific to House Bill 1, we have the fact that historically, even going back to the Constitutional Convention of 1890, all the way through our case law with Franks, that responding to emergencies is primarily an executive function. And the Supreme Court did an unbelievable analysis this summer, in the case that was issued in November under Beshear versus Acre, of not just recounting that history, but explaining not just that our Constitution makes response to emergencies an executive function, but why that was done in our Constitution. We have a part-time legislature. We have a provision that gives the governor the sole authority of when to call the legislature into session, when it is out of session. So all of that points toward the fact that the ability to act in the case of emergencies in the Commonwealth is dedicated to the governor. And there's a simple reason why, because you have to be able to act quickly and you have to be able to move quickly in the case of an emergency. And what House Bill 1 does is robs the governor, and then of course his cabinet, of the authority to take actions that are necessary under sections 69, 75, and 81 of the Kentucky Constitution to deal with the emergency. They have attempted to restrict his use of emergency powers by saying that you can't enforce any rules that we believe that the CDC, even under a non sequitur, and of course that's more of a void for vagueness issue, says are not the least restrictive. So that is the gist of the infringement on the executive power.
Okay, let me ask you, there was some reference in the briefs to the potential problem with regard to the relationship between state government and the federal government, and funding that's available through FEMA and other federal organizations that kicks in during a state of emergency. And I guess I would like to better understand what the concern is there with regard to the limitation of the governor's authority to issue executive orders that would be time limited in terms of the 30-day period unless they're extended by the legislature.
Yes, my understanding of the Stafford Act, which is the act under which FEMA does emergency management, that in order for money to flow down from the federal government to the state government, there has to be an active state of emergency that is tied to the grant money that would be flowing. It's one reason why there's a state of emergency issued with relation to the ice and snowstorm. It enables us to tap into FEMA resources, including Stafford Act resources. If those lapse, then we are at risk of losing federal funding related to whatever emergency you're talking, not just COVID-19, but if there is an emergency related to, I believe you might remember a few years ago when there was the bridge accident in Western Kentucky, when a bridge got taken out. That state of emergency lasted for several months. If there had been an arbitrary 30-day lapse on that, then we could have lost some federal funding that we would have had in order to. And, the response of, well, you can always call the legislature back into session. Well, the framers of our Constitution have committed that as a discretionary matter to the governor, indicating that the governor has broader emergency authority that the legislature can't attempt to backdoor and restrict by holding the governor hostage and requiring him to call them back into session.
Okay. Okay.
To the extent you want to hear about the void for vagueness issues and the others, I think that is probably fully fleshed out in the briefs.
Yeah,
I know we
that's-
discussed that. I will turn it
That was
over.
addressed in your all's brief. There wasn't much said about it by the defendants, but
With that, I'm happy to turn it over to Mr. Mayo for any additional argument. I think we probably dealt with Senate Bill 1 partially already, but I will let him take over
Yeah.
from here and
Okay.
discuss Senate Bill 1 and 2.
all right, Mr. Mayo.
Thank you, Judge. It's Senate Bill 1 and 2. Regarding Senate Bill 1 and 2, the governor and the secretary have presented substantial legal questions regarding the impact of each of those bills on the executive authority to respond to emergencies that the Supreme Court recently recognized in Beshear v. Acree. In terms of Senate Bill 1, and it does limit the executive branch's ability to issue orders, directives, or promulgate administrative regulations in response to emergencies, particularly immediately to respond to the ongoing COVID-19 public health emergency, to 30 days for if they apply to certain entities, or if they apply to quarantine or isolation under Senate Bill 1 and Senate Bill 2 without getting the legislature's approval, effectively forcing the governor to call the legislature into session when they're out of session to obtain such approval, even doing that and coordinating that prior to the 30-day expiration, which would, the Supreme Court in Beshear v. Acree recognized the full-time executive's authority in responding to emergency. One of the reasons being that the Constitution makes our legislature a part-time legislature, not a full-time legislature, as opposed to a full-time executive. And it also Senate Bill 1 creates a patchwork where local governments could seek to extend, local governments within counties or local governments themselves, cities could seek to extend any orders, directives, or regulations, or end them altogether if seek to extend them beyond 30 days if they don't apply to certain entities as laid out in Senate Bill 1. That creates a patchwork that is unworkable in responding to emergencies, which the Supreme Court also recognized in Beshear v. Acree. And Your Honor, it also, Senate Bill 1, we presented a substantial legal question that rather than, as the Supreme Court recognized in November, the legislature itself suspending statutes that are inconsistent with or conflict with emergency orders and directives or regulations, now gives it to the governor, but makes it subject to the approval of the Attorney General, who is a inferior state officer under the Kentucky Constitution. And immediately during this ongoing public health emergency would force the governor to not only take the time to seek that approval, but also await that approval before any statutes that could be in conflict with emergency orders, directives, or regulations could be implemented. In terms of Senate Bill 2,
let me ask you on the Attorney General's role on the suspension of statutes. Is there any provision as to what the scope of the Attorney General's role is? In other words, can the Attorney General withhold his approval of that just because he disagrees with the policy involved, or is it limited to his constitutional analysis that a order may be unconstitutional, or what's the scope of the Attorney General's review, and are there any guidelines in the statute to govern that?
Your Honor, in Senate Bill 1, it does not provide any guidelines. It says that the governor may suspend a statute by executive order when an emergency is declared under Chapter 39A if the governor specifically enumerates that statute in that executive order, and the order specifying the suspension is approved by the Attorney General.
So it
So-
kind of gives the Attorney General veto power over.
That is correct, Your Honor, which would violate our separation of powers under the Kentucky Constitution, and giving him that veto power as an inferior state officer to the governor, who under Section 69 is the supreme executive officer, with that executive authority to respond to emergencies as the Supreme Court recognized. With respect to, unless you had another question on that, Your Honor, I can move on to.
No,
Senate
go
Bill
ahead.
2.
That's
And
fine.
with respect to Senate Bill 2, the governor and the secretary have presented substantial legal questions, shown the irreparable harm that would occur if the bill were to go into effect, because particularly with respect to the restrictions it places on the cabinets and the Department for Public Health's ability to promulgate regulations in response to and to address a contagious or infectious disease in Kentucky under KRS Chapter 214. That any regulation, emergency or ordinary, under Senate Bill 2 would be limited to a time frame of 30 days, including any regulation that orders quarantine or isolation, which would have an immediate impact during this ongoing public health emergency. And it could also, based on the language of Senate Bill 2 and the restrictions it places on the cabinet's authority under Chapter 214, nullify those regulations regarding quarantine and isolation that have been long in effect, because it would remove that authority for those regulations to last beyond 30 days. So we present a substantial legal question on that, and as well shown the irreparable harm that would occur if Senate Bill 2 were to go into effect, and that the equities weigh in favor of protecting the public health during this ongoing emergency and future emergencies.
Okay. All right. Mr. Maddox.
Just a minute, Your Honor.
We'll stand at ease for a second.
I'm sorry, I couldn't find my cursor. Well, thank you, Your Honor. I appreciate the opportunity here. Again, I want to reiterate my objection to proceeding to the merits, but with that said, it seems to us that the governor has simply failed to address what we've argued is his failure to state a claim in this case, because A, he has no standing, and B, there is no case or controversy. And I recognize that may be briefed and addressed later, but it gets to the fundamental issue that Your Honor asked at the outset, and that was, how do the bills impair the governor's ability to exercise power? And respectfully, the answer that it's simply a matter of separation of powers that the governor's counsel offered is fails to address the real issue. So if
let me ask you though, Mr. Maddox, as we kind of delve into this this kind of primary matter that the Attorney General has raised with regard to the whether there's a case or controversy or the governor has standing to address it. I really have a difficult time, kind of getting beyond the line of cases that is most prominently exemplified by LRC versus Brown. It seems to me like the LRC versus Brown is in terms of the nature of the controversy is, if not identical, very close to the kind of controversy that we've got here in terms of the legislature enacting restrictions on the governor with regard to his exercise of power to promulgate administrative regulations and take other actions. It seems to me like that case is, very, very difficult to follow the precedent of that case and to say that there's no case or controversy.
Well, I appreciate that, Your Honor. I mean, the fact is that insofar as Attorney General Cameron is concerned and the effort to state a claim against the Attorney General, that there's no possible injury by the governor. First of all, he hasn't suggested that he has tried to suspend a statute for which the Attorney General has withheld his approval. But beyond that, and I think more fundamentally, it seems that the governor's position is that he has executive authority once he declares an emergency to exercise all of the power that he has exercised thus far. And if that is the case, then anything that, and that power, Your Honor, flows directly from the Constitution. I think that's the reference in the briefs to Section 75, which frankly, we can have a longer discussion about, but the Franks case doesn't begin to suggest that the provision in Section 75 of commander-in-chief status regarding the militia or the Army and the Navy gives the governor the power to exercise total control over the civilian population in all matters of society.
I'm not necessarily sympathetic to a Section 75 argument, but as I said, I'm going to keep an open mind about all the arguments.
Right.
But here, it does seem to me like that the question is more of a pure separation of powers issue. Obviously, and you all have heavily relied on the Brown versus Barkley case that talks about how the governor really only has the powers that the legislature has vested in him through legislation, at least in that case with regard to reorganizations, but arguably that has a broader application. But here the question seems to me is the legislature, what is the separation of powers issue in terms of the functions here? Because here it seems to me, even in Senate Bill 1 and Senate Bill 2, the legislature recognizes that the executive branch of government is better equipped to respond to emergencies because of the highly technical nature of the problem here, certainly with regard to public health. The need to respond on a daily basis to changing situations, to take into consideration medical evidence, to gauge the effectiveness of measures that are initially taken and may need to be adjusted during the course of the pandemic, all of those things. I think the legislature, even in these bills, recognizes that the executive branch, with its Department of Public Health, its epidemiologists, its medical doctors, its network of local health agencies, is best equipped to respond to. But the legislature has again reaffirmed that it's delegating those authorities to the executive branch. But then in Senate Bill 1 and Senate Bill 2, the legislature kind of reserves its options and says, but we're going to take that authority back if we don't like the way you did it. And that to me seems to be a kind of a pure separation of powers issue.
Your Honor, Mr. Lykin and Mr. Fleener may have, more to say on that from the legislature's perspective. From the Attorney General's perspective, I can tell you that I'm not aware of anything in Kentucky jurisprudence that defines the separation of powers doctrine with respect to how power is divvied up within the executive branch. So the notion that somehow the separation of powers sections in the Constitution limit the legislature's ability to provide some authority to the governor contingent upon another executive officer's concurrence I think finds no support in the law. And on the larger picture of what Your Honor has highlighted, I think you're correct that the legislature has recognized that, good public policy certainly calls for the Cabinet for Health and Human Services, Commissioner of Public Health, and others to have active roles in providing for these sorts of situations. But the question I think is fundamental to the case that we have made, whether Your Honor has authority at this point to offer any relief with respect to the Attorney General. It's hard to understand how Your Honor could enjoin the Attorney General at this point from exercising authority that comes directly from the legislature via Section 15 of the Constitution. And I could be wrong on this. I only got the governor's reply last night, a few hours before I went to bed, but I don't believe they ever address the fact that Section 15 very clearly says that there is no power to suspend laws and that shall be exercised unless by the General Assembly or its authority. And yet, as I read the governor's papers and listen to the arguments, it seems that the governor's position is that once he declares an emergency, that emergency lasts indefinitely as long as he decides it should last. The legislature can't end it or change it, even though he signed SB 150 into law last year, which gave the legislature that authority, or at least reclaimed it. And more importantly, Your Honor, once he declares an emergency, he has the power, Section 15 notwithstanding, to suspend any law, every law, as long as he chooses. And that's a fundamental question that one has to answer. It seems to me they believe it comes. I'm sorry.
The scope of the ability of the executive to suspend a law under this authorization from the legislature, I think is a legitimate subject of debate. But I guess your larger issue with regard to the issues we've got before the court now is you're just arguing that all of those issues are premature now because the Attorney General hasn't taken any action or been asked to take any action that would trigger that kind of review.
Well, that's correct, Your Honor, and it dovetails with, I think, the argument that I believe the governor has made, which is, he has executive authority, so he doesn't need power from the legislature. If that's the case, then he hasn't been injured by any of these bills. He couldn't be. He could simply ignore them and allow others who believe that he is ignoring the law to sue him. But B, if he does need the authority under either KRS 39A or under SB1, SB2, or HB1, then he can't argue that insofar as the Attorney General is concerned, that there has been some injury to a power to suspend laws that only the legislature controls, and the legislature can give him that power if it so chooses, as it did in 39A 180 sub 2, or as it is now chosen to limit that in SB 1. So, that we think is a fundamental question.
I guess the other argument with regard to the Attorney General's role here in terms of separation of powers is, can the legislature order the governor to comply with the legal advice of a lawyer who he may disagree with? I think there is an argument that it's an infringement on the executive function for the legislature to order the governor to take the legal advice of the Attorney General if the governor good faith legal basis to disagree with the Attorney General.
Well, Your Honor, in SB 150 last year, the legislature modified the power in 39A 100 sub L, I believe, to address elections. And it did so by further limiting any power concerning the manner in which elections are held by requiring the recommendation of the Secretary of State. So in that case, the governor had no power to modify the manner in which elections might be held without the concurrence of another officer, the Secretary of State. And I think that this section is similar to that section. So, I'll just, conclude, Your Honor, by pointing out that I think that the governor's papers draw heavily on the notion that the ACRE decision from last summer answers all the questions raised by the complaint here and the motion for injunctive relief. But I think it's actually quite different from that. In that case, the Supreme Court referred to the case in Michigan where that legislature had something called the Emergency Management and the Emergency Powers of the Governor Act. And the court said that the Emergency Powers of the Governor Act gave the governor power indefinite in duration to declare an emergency and issue reasonable orders, rules, and regulations as he or she considers necessary to protect life and property during an emergency. And our court then said that we differ from Michigan because our governor does not have emergency powers of indefinite duration. And it cited, of course, SB 150, which provides that if the governor didn't end the emergency by December 31, then the legislature could do it when it resumed, its session.
And I understand that in a large sense, these three bills are the legislature's reaction to the ACRE decision and the legislature's ability to rein in what they view as the governor's abuse of his authority in some respects, and the legislature's attempt to place limitations on that. But we still get back to this issue of, where do you draw the line, and at what point does the legislature have the authority to limit the governor, and at what point does the governor have executive authority that the legislature is not under the Constitution empowered to infringe? So it seems to me like we still have a separation of powers issue. And
Your Honor, I think you're correct, obviously, but I think the ACRE decision in that discussion also pointed out that, the check that we have on the overbroad assertion of governmental power by the governor is what the court said was a legislative amendment or revocation of the emergency powers granted to the governor. And I think that we have to read that to mean that the legislature could simply have repealed 39A.
Yeah.
And it seems difficult to conclude that they could repeal 39A, but they can't modify it.
Yeah.
Which seems to be the governor's position. And I'll just finally on the jurisdictional question and the separation of powers issue, Your Honor, we cited in our case the Commonwealth versus Mountain Truckers Association case. And, that case addressed a restraining order that would attempt to bind the Commonwealth and everyone in it, all of its executive, judicial, and legislative officers simply by the nominal participation of the Commonwealth. And the court struck that down. It said such an order would run contrary to the very essence of injunctive relief, and nor may all the courts of Kentucky, other than the Franklin Circuit Court, be automatically divested of their jurisdiction to hear matters simply by the issuance of a restraining order, including the Commonwealth as a party. Your Honor probably knows that there is a case pending in Boone Circuit Court right now in which parents of school children have sued the local school board, claiming that the school board is acting in reliance on the suspension of KRS 158. That statute requires that schools, that there be in-person instruction. Of course, Dr. Stack indicated earlier that the schools are free to provide in-person instruction, but the school board there is doing it. Now, that's a live case in controversy. I'm not sure if Your Honor would expect that an injunction here today, or whenever Your Honor might address that, could somehow, bar that case from going forward. I mean, that's a live case in controversy where
I wouldn't really, I've never been of the view that any circuit court can enjoin a proceeding in another court. And, I don't think that's really, but there are, that's one of the issues here is that there, there's a whole host of context in which these issues can arise, and certainly they can be litigated in any venue where they're, where controversy arises. But the parties do have a right, I think, to a declaration of rights as to the validity of the law and the constitutionality of the statutes that are being challenged. Whether that ultimately comes here or from another circuit, it's going to ultimately come from the Kentucky Supreme Court.
That's true, Your Honor, but typically that comes in the context of a case in which there is, some actual controversy. Now, they've cited cases suggesting that somehow the Declaratory Judgment Act is effectively an exception to the requirement that there be, a case or controversy. I think that the case law we've cited says otherwise.
Yeah. I would say this, I mean, we'll delve into these jurisdictional arguments, I think, in more depth a little bit later, but it's still, it is an issue that I think, again, unless the Attorney General is coming before the court and saying, I agree with the governor, these statutes are an overreach and they violate the separation of powers, which the Attorney General is obviously not doing. If the Attorney General agreed with the governor, I might well agree that there's no case or controversy. But if the Attorney General is defending the validity of these laws, then it seems to me like there is at least initially a case or controversy with regard to the interpretation of the statute that the parties are entitled to have adjudicated. But we'll delve into those arguments a little bit later. Right now, I think we're going to limit our argument to the injunctive relief, and I would agree. The court's not going to issue an injunction unless have made at least a preliminary determination that there is jurisdiction here, and so far I think I've crossed that hurdle. But okay, anything else, Mr. Mack?
Yeah, Your Honor, I would just conclude by, reiterating that if the governor believes he has emergency powers under the Constitution, then he isn't injured in the least by, some limitation in a statute that he believes doesn't affect him. And if he does believe he needs legislative authority, then, it's plain that the legislature has the authority to do that. So we would oppose, obviously, the motion. and appreciate the opportunity to address the other issues in due course.
Right. Okay. Thank you, Mr. Maddox. Mr. Lycan, anything you wanted to add in by way of
Absolutely.
closing? Yeah.
Yes, Your Honor. So aside from the fact that Dr. Stack's testimony was almost entirely opinion testimony and legal opinion at that, I would posit to the court that it is entirely irrelevant to the question that is actually before the court today. The questions before the court today are the legal questions, one, of this court's jurisdiction, and two, the authority of the General Assembly to decide how much of its authority to delegate to the executive branch and how much of its role as policymaker it can delegate. You know, as to the immunity question, this court has no jurisdiction to issue even declaratory relief against the speaker. So we can cover that at another time.
Right. Right.
But Dr. Stack's facts and his opinions either have been or should have been presented to the General Assembly. His role is to attempt to persuade the General Assembly to adopt his policy preferences. And then the General Assembly can decide whether it agrees with his opinion. So Dr. Stack's testimony was in sum that he disagrees with the policy choice of the General Assembly. So the General Assembly has other concerns. Dr. Stack's job is to be concerned only with health outcomes. His job does not require him to balance those outcomes with the liberty interests and bedrock rights guaranteed to our citizens by the Constitution. That cost-benefit analysis is made by the General Assembly, which is entirely its providence to judge. Now, in this particular case, the General Assembly is not micromanaging decisions about COVID. This is frankly not about COVID. The General Assembly is asserting that the executive does not have unilateral, unlimited power to act as it pleases in derogation of the Bill of Rights. If the General Assembly has decided to delegate that power for a period of 30 days, and if the governor feels that he needs more, he can call the General Assembly in a special session, and in 5 days, they can extend, or less, and no more than 5 days, they can extend that emergency power. Now, if the governor does not feel the emergency is sufficiently critical to call the legislature back into session, that's his choice. There's not holding hostage. There's no forcing the governor. It's simply, we're going to delegate you that power for X amount of time. And then after that, that delegation of power is rescinded. Your Honor, you made the
I guess
point
that again is kind of the question here. Can the legislature delegate the power to the governor and then take it back by requiring the governor to bring them back into session and to enact another piece of legislation? It's a you know, I don't know, it's a model that I don't think I've ever seen before, either here or in any other state. But again, I understand your argument that it's the legislature's power to delegate and to reclaim as they see fit. But I think that's an open question. Yeah.
I will say that many other states have this kind of a model. They most of them, if they don't, it's because they have a General Assembly of continuous session. Kentucky is one of a handful at best who are either not in session to check the executive or have given just an unlimited time for the executive to wield those powers.
Right.
I don't believe, Your Honor, it's that the General Assembly is taking anything back. Certainly not just because it disagrees with those policy preferences. It's just limiting its delegation.
Mm-hmm.
If it disagrees with the governor's policy choices when it's in session, as it is now, I don't think anybody would argue that they don't have the power to pass a bill.
The legislature can pass a bill, right?
Right.
Right.
But just specifically voiding one of his executive orders, a specific executive order. I don't think there's any question they can do that. The question in LRC versus Brown, as I understand it, was that the General Assembly was attempting to delegate itself authority when it was not in session to check the executive. It's not that they delegated him authority and took it back. They were trying to act when they were not in session. So I think that the General Assembly delegated the power to the emergency power in the first place, delegated the power to make regulations in the first place. The General Assembly can limit those as they see fit. Nothing requires the governor to exercise his power to call them in a special session. That's his choice. If the emergency is that significant, the General Assembly should be back in session. It takes no more than 5 days to extend the emergency and give him the exact same powers he has. Thank you.
All right. Mr. Fleener?
It's been a long morning, Your Honor, and I'm not going to spend a lot of time, but a few things I would like to highlight. And one is it's kind of the measured way that the General Assembly has acted here. When General Assembly came back into session on January 5th, it had every ability, based on Senate Bill 150, which the governor signed on to end the emergency. They didn't do so. They didn't think that was prudent at the time. As Mr. Likens has pointed out, they could have passed bills ending each and every one of his executive orders, but they did not do that. They did instead put a time limit, which, as Mr. Likens pointed out, is and I think is in my brief, is a very common mechanism in other states, that after 30 days, he needs to somehow justify continuing these to the General Assembly. As Dr. Stack testified, he's made no attempt to do that. He said, kind of in a cavalier way, that he hadn't been invited. I would let him know that he will probably receive that invitation before the day is out to come talk about those specific executive orders. But that ability is there. The clock is still running unless you let the governor out from underneath the requirement that he so do. We are looking at this, particularly Senate Bill 1, this morning through COVID lenses. But as the Supreme Court in Acre pointed out, there have been, like, since 1998 when 39A was enacted, I think 96 different emergencies declared by the governor. Only one has caused the stir that this one is causing. Ms. Cubbage gave the example of the bridge problem. We dealt with that, and we dealt with the FEMA problem with the very mechanism that they seem to be concerned with now, that are localities, the counties affected, and use the ICE emergency that's going on right now. If after 30 days, there are counties that are still affected and need FEMA funds, they, by application of the judge executive to the governor, that can be extended for an indefinite period of time. And those funds still come in, and it doesn't require the legislature to be involved at all. That's going to take care of probably 95 of the 96 emergencies that this 39A has been used for. The governor in his brief relies a lot on separation of powers, but I would caution to the court, that's a two-way street. And there are certain things that are inherent to the legislative function, particularly the suspension of a statute, the repeal of a statute, the modification of a statute. And that is what the legislature is exercising here. The legislature has modified a statute which it's granted, both with respect to 39A and with respect to 13A. Mm-hmm. We have given the governor every opportunity to make his case as to why any of his executive orders or all of his executive orders need to be extended for another 30 days, for 60 days, for 90 days, whatever. He has the ability to make that case. And in fact, right now, he doesn't even have to call a special session. The General Assembly is here in town. He can make that case presently, and he has until March 30th, until the session constitutionally ends. Really, I think those are the points that I want to make. We're dealing with the limitation of a statute, which the General Assembly granted, and somehow once 39A was enacted, it didn't somehow become, holy writ and can now no longer be modified, repealed, whatever. That's still a legislative function. And if there are inherent powers, which the governor seems to think he has in the Constitution, then he needs to issue his orders based on those inherent powers and let that be litigated by the parties being affected. One last thing, and I did a late filing of, with respect specifically to Senate Bill 2. One of the things
The
that
pharmacy regulations that,
the policy regulations, the ability now to amend an emergency reg, which you heretofore couldn't do, is proving very helpful to some of the agencies, like the pharmacy board, that they've got an emergency reg in place that they want to get amended to come into compliance with federal guidelines. They now have the ability to do that. And I would hope that that baby doesn't get thrown out with the bath as we address that, because that's something that was put in to help the executive branch. You know, as I said in the very beginning, we acknowledge LRC v. Brown is still in effect, and the role of the Reg Review Committee is advisory, but still with the concurrence of the agency, we now have the ability to modify these regs.
okay. All right. Ms. Cubbage, I'll give you, well, let me ask Mr. Wolseley, does he have anything in addition to add?
Your Honor, the only thing I'll add is we have repeatedly said that the LRC is not a proper party to this litigation. You mentioned LRC versus Brown, and I'll just simply note that that action was actually filed by the LRC.
Right.
So in that case, the issues that the Attorney General brought up relating to standing, case and controversy, and our arguments relating to proper parties and immunity were not litigated in that case. They had no bearing on the case. And it really has, LRC versus Brown has no bearing on any of the issues we've raised.
Yeah, on those jurisdictional arguments. Yeah.
That's correct, Your Honor. I'll also note that at least as it pertains to Senate Bill 1 and 2, the governor's office and Secretary Friedlander have merely asked for an injunction against the bills in their entirety. They've not said specifically what the LRC should be enjoined from doing. Both Senate Bill 1 and 2 have severability clauses. And so at the very least, there are a number of provisions in there that the LRC could continue to carry out that have not been specifically attacked.
Yeah, Mr. Fleener was alluding to one of those, I think. So, okay. All right. Thank you, Mr. Wolseley.
Thank you, Your Honor.
And Ms. Cubbage, I'll let you have the last word if you.
I will keep it very brief because I know it's been a very long day and you have a very extensive record. I think just in general to all the arguments, there's been a lot of talk about the governor claiming expansive powers and this is all in the abstract, but it's really not. We are talking about these 3 specific bills in this very specific context. And this is not an issue where we have until March 30th and the legislature could extend things. March 4th is when the current executive orders are going to be extinguished. So we believe we have clearly shown a case or controversy here, but with specific reference to the idea both that the legislature can give and it can take away. Well, that's true if you're talking about delegations of legislative authority. The legislature can't deign to give executive authority because that comes from the Constitution. And sections 27 and 28 indicate that not one branch can't exert the power of another branch. So that's what we're talking about here. So even if we are talking about if 39A is a legislative enactment, that it's a legislative grant of power, even if there were things they could take back, they can't do that in an unconstitutional way that infringes on the executive, such as the requirement to come back after 30 days. That puts the Section 80 discretionary power in conflict with the powers under 69 and 81 to take care that the laws be faithfully executed and that the governor manage the executive. If there is an emergency, what this 30-day requirement does is puts the governor in it truly is blackmail in a sense of either he's got to ignore his responsibilities under 69 and 81, or he has to call them into session. And that is precisely what the framers stated is not the point of the call for an extraordinary session. So yes, the legislature gets to set policy. They get to act within the legislative sphere, but they can't enact legislation that violates the executive branch or tries to take away those powers. We understand that this is not about just policy choices. This is about the separation of powers, as you've recognized. But with respect to the fact that we're here on injunctive relief, we believe that Dr. Stack and Mr. Hart amply showed the harm that could that could befall the Commonwealth, not just with Senate Bill 1 and 2, which present longer term issues, not just related to COVID, but House Bill 1, which was not addressed in particular by any of the argument today other than by us, as far as how we would address the COVID crisis on a going forward basis. So we believe we have met all of the requirements for injunctive relief here. We believe these present very serious issues that deserve a full airing, but while we do that, we believe that we are entitled to injunctive relief so that the governor can continue to manage the COVID pandemic.
Okay. All right, let's address before we recess here. Let's address just a couple of the procedural issues we alluded to at the beginning. I guess one of them, well, a couple of things. Well, one thing I would like for you all to do is to file something here within the next couple of days. I'll say by Friday, a listing of all of the all the currently binding executive orders and emergency regulations that would, and a brief summary of what their subject matter and effect is. That would, all of the currently binding executive orders and administrative regulations that would expire under the terms of Senate Bill 1 and Senate Bill 2, absent some legislative action within the 30-day period that Ms. Cubbage indicated that the expiration date would be March the 4th, I think. Does anybody disagree with that? Or I think I heard March the 2nd. I'm not sure when the 30-day clock would run, but certainly it would be early in March.
I would agree with March 4th, since there are 28 days in February.
Yeah, okay. Okay, so we'll within the next couple of days, I would like the parties to make a filing that would identify the currently binding executive orders and emergency regulations that they maintain would be covered by Senate Bills 1 and 2 with just a very brief description of the order or emergency regulation and what its purpose and effect is. I'm also going to at this point, the restraining order issued by the court really only applies to a section of House Bill 1. I'm going to continue that restraining order in effect until I issue the ruling on the motion temporary injunction and the motion to dissolve that the Attorney General filed. But I'm going to do my best to get you all a ruling on the motion for a temporary injunction and the motion to dissolve the restraining order by within the next 10 days or so is my hope and my plan is to do that prior to the expiration of that 30-day period, so that whoever is unhappy with that can seek appellate relief if they choose to. And I guess the other thing is that the Attorney General has filed a motion to dismiss and briefed these jurisdictional issues with regard to whether there's a case or controversy and whether the governor has standing. The reply filed by the governor last night, I think, addresses much of that. And certainly I'll let anybody else, supplement their briefs if they want to, but it seems to me like that is pretty close to being the Attorney General's motion on that point. It seems to be about ready to submit, but I'd like to get any input from Mr. Maddox and Ms. Cubbage. I understand Mr. Fleener and Mr. Lyken and Mr. Woolsey, their time to file a responsive pleading hadn't run yet. And I understand they're all going to be filing motions to dismiss based on legislative immunity, and certainly will allow them to do that in due course, and we'll do a briefing schedule on that when the time comes. But the Attorney General's motion has been filed and at least initially briefed. So I'd like to get Ms. Cubbage and Mr. Maddox's views if we need additional briefing on that, or if the court can go ahead and take that under submission.
Your Honor, we would like a chance to brief it more fully. We obviously wanted to get something in anticipation of this hearing today, but that was on a truncated basis. I don't know that it would be extensive what we would give, and obviously we believe Mr. Maddox should have the opportunity to file a reply since it was his motion. So, you know, we're open to, depending on the time schedule you would like, we could get a supplement in say 10 to 14 days. And then Mr. Maddox have an opportunity to file a reply.
Okay. Is that agreeable, Mr. Maddox?
Your Honor, we'll follow whatever schedule you suggest. We do appreciate the opportunity to reply to whatever additional briefing there is.
All right. Well, since the parties do want to supplement the briefs on that, I'm going to allow them to do that. So let me just I'll give Ms. Cubbage give the plaintiff 2 weeks from today to file a supplemental memorandum in opposition to the Attorney General's motion to dismiss. And how long do you want for your reply, Mr. Maddox?
Honor, if we could have 10 days, that would be great.
Okay, we'll give 10 days thereafter for the Attorney General to file a reply, and then I'll take the Attorney General's motion to dismiss under submission. We may have a supplemental argument on that after I've reviewed the briefs, but I'll reserve on that. And then with regard to the legislative defendants, obviously we'll let you all approach that however you think is best. But assuming you do file motions to dismiss on legislative immunity, we'll enter a separate briefing schedule on that at the time you file the motions. Can you all tell me when you anticipate filing those motions?
Your Honor,
it's honestly hard to say. We got some things going on top of the hill, but I don't even know what the deadline is. Dave?
I would assume we'll file that within about the next week or so.
Yeah, I mean, I think
they've done that motion before, so it'll be.
They're going to be due probably within the next week or so. So I would just suggest that when you all file your motions to dismiss, that you all consult with counsel for the governor and see if you all can't submit an agreed order on a briefing schedule on that on those motions, and we'll just get to those in the ordinary course of business. Okay.
Yeah, we're happy to coordinate that with Mr. Fleener and Mr. Lycan. And obviously, if they need any additional time, whether it's 1 day or more, we're obviously happy to agree with that as well. All
right. I'm sure you all can do that. And I appreciate your all's working things out on those kinds of issues. So, okay. Well, I've got a full plate then of things to review, and I'm going to, again, try to get you an order within the next 10 days or so. I am going to enter an order today that will extend the restraining order until such time as I've issued the ruling on the temporary injunction, which I'll again try to make a priority. If I need additional input, I'll let you know. I would like to get those, if you all could each file a notice, or if you can do it jointly, even better, of the executive orders and emergency regulations that would expire absent action by the General Assembly. So
yeah, we're happy to prepare that and circulate it to the other parties to see if we can agree on the scope of what we think those are.
Okay, that would be great.
Thank you.
Okay. All right. The only other thing I would say before we recess is that again, I appreciate all of the arguments and the briefing that has been submitted. It's been very high quality and very helpful to the court. I think I indicated at our initial hearing here, the court's hope and desire that the parties would continue to see if they could find some common ground and a way to resolve these issues, either temporarily or permanently. And I know the legislature is in session now for a limited period of time, which creates, I think, a window of opportunity to see if something could be resolved that would address these issues. I would also just offer the observation that, I think there are two separate sets of very important concerns that this litigation presents. One of them is the impact of this legislation that's being challenged on the public health response to the COVID pandemic and the public health implications of that in terms of the, the public interest and the urgent need to have an effective response to a pandemic is, an extremely important consideration for the court. I will also say I recognize, on the other hand, the important concerns that have been raised by the legislature in terms of, the balance of governmental powers and whether the governor's actions, have placed an undue burden on certain segments of the public and raised issues that the legislature is legitimately concerned about. And again, the very valid concern about whether there has been an appropriate balancing of the powers of government to address these concerns. And, it has almost always been my experience in dealing with these kinds of problems in disputes involving state government that at the root of this dispute and many others is a communications gap, a communications problem. I think that has been evident here today. And I would urge the parties to see if you all can't enlist the help of of people who are knowledgeable in these areas to see if you can't find some common ground in terms of ways to address this that will protect the legitimate interest of the legislature and the governor. And I will say that in my long experience in Frankfort, it has almost universally up until recently been the case that public health issues have been dealt with in a nonpartisan way. Mr. Fleener alluded to the fact, I know he worked for Dr. Fletcher and Dr. Holsinger. And I think typically the administration of the Department of Public Health and the response of state government to public health problems has always been nonpartisan. I know that throughout the legislature's history of dealing with this, there have often been, I know Dr. DeWeese, who's no longer with us, a very fine Republican representative from Louisville, took an important role in shaping public health policy in the legislature. And we've had other doctors that have served in both houses. And I just, I feel confident. I think it's, in many ways it is difficult in the crisis of responding to a pandemic. It has been difficult for Dr. Stack and his colleagues to adequately address all the questions that the legislature has. But I also think that there are, plenty of talented, dedicated civil servants in Kentucky, and at our universities and elsewhere who the legislature could enlist and rely on to work with the executive branch of government to address the legitimate concerns about the public health response, and that would go a long way toward resolving these things. And certainly, there are questions about, the powers of government and how they should be distributed that are not necessarily public health questions. But we have, in this case, we have the intersection of these political questions with regard to the distribution of powers of government that have come, head on in conflict with the public health response to a pandemic. And I think that, without an extraordinary effort from all the parties that are represented in this litigation, the result of this is not going to be good for the public unless all the parties who are involved in this litigation are able to, to try to find a third way to, to address these problems and to do it in a way that respects the roles of both the legislature and the governor and the fundamental underlying concern with how do we advance the cause of public health and protect the public from a raging pandemic that is very deadly and that has caused tremendous loss of life throughout the state already. And I just feel that I have great confidence in the integrity and the ability of all of the counsel who are appearing in this case. And I want to just make a request that you all, I know you all have full-time jobs on many fronts now, maybe more work than anybody can do, but I hope that you all will be able to carve out some time to engage in discussions about how to improve the communications between the executive and the legislature on these issues of public health, and whether there couldn't be some alternatives that would address the legislature's concern with accountability in terms of the executive branch's response to this pandemic. And I think whether that is done formally or informally, that there are, there are ways that those problems can be solved in a way that's going to be better for the public than if they're just solved by litigating the legal issues and resolving it through litigation. So I want to urge you all to do that and to do that on top of the all of the other tasks that I know you're juggling right now. But I do think that there are qualified people in the field of public health who are ready, willing, and able to assist the governor and the legislature in addressing these problems. And I think that kind of an effort would be very worthwhile and might help lead to the resolution of the problems that we've got before the court now that are only in a limited sense legal problems, that they're in a deeper sense they're problems of life and death for the people of Kentucky. So I do want to urge you all to give some time and some effort and some thought to whether you all could not propose some form of enlisting of people who have expertise and knowledge in the field of public health who might assist in that kind of an effort. So I'll leave that with you, and I will enter an order that will outline the things we've talked about here. Appreciate getting the additional briefs that we're talking about, and do my best to get you all a ruling on these issues in a very short period of time. So unless anybody has anything else to add, I'm going to go ahead and the court will stand in recess.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Judge. Thank you, Judge.